members of the legislature. I was not there. No one from Texas Trial Lawyers.
Well, I'm not saying that y'all were present.
Yeah, we weren't in the room.
Let me finish. Would you mind? Okay. I'm not saying you were present. I'm saying your interest was present, not that you personally were present. That's what I'm saying.
Let me go to Senator Johnson.
Thank you, Mr. Chairman. I wanted to pick up where Senator West left off. Representative Lucio, at the time that amendment was negotiated, successfully negotiated,
Yes, sir.
it resulted in quite a few members of the legislature in the House and the Senate throwing their support behind a bill that they had previously refused to support. Is that correct?
I would say that's correct, yes, sir.
I can tell you it's correct in the Senate, and I can tell you it's correct as between some members of the Senate that are sitting on this dais. So, the history is not just about compromise among the parties. This bill passed as a result of that compromise. Otherwise, it might not have. Would you agree with that assessment?
I mean, it was highly contested, yes, sir.
And people changed their votes as a result of that negotiation, right?
If I may.
Please.
Yeah, if I may. It was my intention, I can't say everybody else's intention, only my own, to try to have meaningful reform. And the reason, and frankly, I wasn't even working on that bill until 24 hours before it was to be on the House floor. I was called in last minute because it was highly debated amongst members. We were trying to do our best to strike a bill that would not shut the doors to the courthouse for plaintiffs. That is not my intent. But we needed meaningful reform, relief. What I've seen, Senator, I'm a small business senator. I'm a small business owner. I have 2 franchises, is that every year my insurance rates go up. And that's built into my base rent, triple net. But then after that, I still get a $10,000 true-up for each location at the end of the year. And when I call my landlord and say, what's happening? They said, we have these rising costs of insurance. So the compromise was, here's what we believe will provide reform and cut down on these extreme cases that we were seeing growing and growing. And what I can tell you today is that those cases continue to grow and grow. Those verdicts continue to get bigger and bigger. Those lawsuits are more and more in every county. What we did in 21 was never really adopted or used as a trial option because trial courts and lawyers have told us it was confusing in how the standards were, or the ones we built into the bill were going to be used or interpreted at the court level. I think the basis of HB 19, I would have voted for even without my amendment because I believe we need relief. I'm not trying to undo anything. Frankly, I just want an opportunity for an option at the trial court level that would be meaningful to contain and reward plaintiffs justly, but not beyond what I remember in law school as a principle of making plaintiffs whole. And what we're seeing is evidence that prejudices the jury and results in these nuclear verdicts on fact patterns that just are astonishing to me and many of my colleagues that are lawyers that don't practice plaintiff's law, that don't trial work.
Finally, one more question. Mr. Island, you described what seems like an alarming scenario in which liability is going to go it's going to be foreclosed. Does anyone on the dais disagree with what Mr. Island said about the ability to pursue the owner if they're unable in the first phase of the trial to present evidence of the owner's culpability?
I could not disagree more strongly with everything Mr. Island said. Completely, absolutely wrong about how this bill works. Completely. Under 72.053, you load the truck wrong, it comes into evidence, you're going to be liable as an owner for that. The brakes fail, it comes into evidence, you're liable as an owner for that. This has to do only with the employment-based claims. That is, did your employee, was he drunk or high or whatever? Now, that evidence is coming in too. If the employee was drunk, high, been in the cab too long, all of that's coming into evidence because all of it could have caused the accident. It's all coming into evidence. The only question is it coming into evidence to support a claim for negligent entrustment of the truck? That is the only thing we're talking about here. Negligent loading, negligent brakes, negligent maintenance, all of that comes into evidence under this law today, and nothing you're doing today will change it. I could not disagree any more strongly with what Craig Allen said about this bill. It is just simply wrong.
Mr. Island?
Yep. It can come into evidence, but the company's not going to be in the phase one of the trial under this bill as it is written. That's true. Under 053, it says evidence can come in, right? But there's not going to be the company there to assign responsibility to in the first phase of the trial as this bill is written, because under 54A, it says no exceptions. We strike out the exceptions. That's the whole point. The whole point of the amendment in the House to say if you violate all of these safety standards, that's the exception. Under 54A, the very first thing is it strikes out exceptions, right? And then it strikes out C, D, and E over in later in the bill, and it leaves F, but there's no way to get the company into the first phase of the trial under this committee substitute as it's written.
It's just wrong. 74A is based on, says it plainly on the face of the 74A, based only on respondeat superior. Respondeat superior is an employment doctrine. It has nothing to do with negligent maintenance. 74A is talking about respondeat superior. Are you liable for if you concede that you're liable for that employee's negligent actions, you are on the hook to pay the damages under respondeat superior. This whole conversation is about those employment torts. Negligent loading the vehicle is going to be on the jury charge. Nothing you're doing today changes that. I guarantee it. I guarantee it. This 74A is talking about respondeat superior only. And Craig reading it some other way does not make it true. It is, and it's plainly in the words of the thing. And so and the exception is, except as provided in paragraph D. Well, section D of this thing really makes a mess. Section D of this thing right now today, D1 says, if the trial is bifurcated under 72.052, evidence that is admissible under subsection C. Evidence admissible under subsection C is that the employee was drunk, high, over his time in the cab, and some other things like that. So that evidence is admissible in the first phase of trial only to prove ordinary negligent entrustment by the employer defendant. So subsection D says that the fact that that person was drunk, if you plead negligent entrustment, the fact that he was drunk is now only used to prove negligent entrustment. You can't even use it to prove that he ran the red light. If you read subsection D literally, and court should, you can use the evidence that he was drunk either to prove negligent entrustment or that the employee ran the red light, but you can't use it to prove both. That's the way the thing reads right now. It is not the way the law should work. And so when you take out that exception, when you take out paragraph D, you're doing the plaintiffs a real favor, because right now the evidence is limited to A or B. It can't be used for both. 74D goes further to say the evidence admissible under subsection C is the only evidence that may be presented in the first phase of the trial on negligent entrustment. So you didn't train your driver to drive a particular kind of vehicle. It has a particular kind of load. You didn't train him to do that. That would be negligent entrustment, potentially. Your failure to train the driver, and therefore you put an untrained driver on the road, is negligent entrustment. Under D2, it's inadmissible because it's not drunk, high, overtime in the cab, or the other things that are listed in paragraph C. This thing, paragraph D, actually says that if you plead negligent entrustment as a plaintiff in one of these cases, you are limited to this little sliver of the world of negligent entrustment, and you can't even prove that the person was improperly trained about how to drive his truck. The amendment that went on in the House says, and that is literally why it's not working today. It has nothing to do with negligent maintenance, nothing to do with the brakes. It has to do with the employment based tort negligent entrustment? Did you put somebody in the cab who shouldn't have been there because they're a bad driver?
Okay, let the record show that Senator Hagenbu is here, Senator Miles is here. Senator Johnson, did you get your question? Yeah, you just turned it off. So we'll go to Senator Hagenbu. I think you had your light on first.
Yes.
Question.
Thank you, Mr. Chairman. Mr. Lucio, you're an attorney and a former state rep, correct?
Yes, sir.
So, and you worked in this bill at some length, right, to try to get it right and make it fair and just, sort of fair and reasonable on all sides, correct?
Yes, sir.
Yeah, then it's you.
And you've decided that the Lucio amendment doesn't make sense at this point, correct?
In practice, it has not been used because the feedback we get is it's confusing trial courts, it's confusing plaintiffs and defendants, and only the traditional method of trying cases remains.
And I'm not a lawyer, sort of pull up and put it in layman's terms, I think. The intent of the law originally was to make sure that the first phase of the trial was straight up, what are the facts and who's basically at fault, right?
Correct.
Without bringing in a bunch of, years of information about the trucking company, as long as they, I don't know legal language exactly, as long as they stipulated that the driver worked for them, then it was just based on the facts of the case. Wasn't years of all kinds of information about the trucking company from 30 years ago or all kinds of stuff. It was based on what happened at that point in that accident, correct?
So, correct.
That was the intent of
the original bill. Yes.
Right. But because of this exception, which we're talking about right now, which is still one of the gentlemen here is still trying to get back in again or keep in, the exception ruined that attempt to try to make sure that it was just based on the facts of the case, correct? Basically, right?
That is the feedback we're getting from practicing
Okay.
trial lawyers. Yes, sir.
Yeah. Thank you very much.
Yes, sir.
All right,
Thank you,
Senator
Chairman.
Perry.
Thank you, Mr. Chairman. A couple of things. One, the conversation around we're now changing something. We make laws every day in this Capitol for 140 days that when we come back 2 years, 4 years, we figure out whether we got it right or not. So that's not unprecedented that we change bills. I'm not an attorney. I've said this before in other hearings that you guys show up. Just in a layman's perspective, and I don't care who answers, if I'm wrong or right, you're not going to hurt my feelings. If I killed somebody today, the first part of this conversation is to determine, did I kill somebody today? If I had killed somebody 30 years ago, that's not part of today's presence. That doesn't interplay on today's trial for what I did today. However, the next piece, you get to bring up the fact that I've killed people in the past. Am I looking at that right? That you get to bring in other facts to kind of determine at what level maybe I'm not a good person. So just in a layman's perspective, it's about today, and what I understand the friction is we bias the jury was past, kind of your part, but in just a very simplistic term, it's about what I did today, no matter what I've done in the past in the first part. But in the second part, you get to tell everybody that I'm a really bad person. Is that kind of a
Senator,
layman's perspective?
If I may, as I understood it and how we talked about it is that companies pass acts that in most cases had nothing to do with the cause of that accident when brought into phase one of the trial could prejudice the jury.
No, I agree with that.
Right. So what we wanted to say is, okay, let's clear the path here and just talk about who caused the accident, what was the cause of the accident,
Right.
and determine compensation. When an employer accepts responsibility for the driver, then negligent entrustment in a typical case is not a plea anymore. They accepted responsibility for the driver.
So in my example, if you don't tell them I've killed someone in the past in the first phase, I agree.
Of the idea of punishment, right, in a criminal trial is correct. But the concept of accountability in phase one, right, is not temporal past acts to prove negligence in phase one. By very definition, I can't use things that are not relevant to the responsibility of the company that caused the wreck. The question is whether a company that has 80,000 power units driving 85,000-pound tractor trailers across the United States of America has a responsibility beyond simply saying that's our driver. And the law says it does. But for these people that have been injured by somebody that wreck on I-35 last week, You've got a foreign national with a questionable CDL with 3 priors and a pending speeding ticket on the driver's record known by the company that has put him behind the wheel. And the company says, that's our driver. But we sent him out. We knew he was dragging down the road, and he comes into a construction road zone doing 80 miles an hour, knowing that he's got these issues on that day, not past, on that day. And he plows into a family of 4 and kills them in a construction zone. Now, under this scenario, if this gets all repealed, the company says, that's our driver, and comes in and defends the case in 3 ways, because I actually try these cases. The first thing they do is they say, Williams Brothers Construction failed to have traffic safety controls, and they should have limited speed earlier down the road so that that truck driver never hit that family. And then they responsible third party in a disabled car in those 2 lanes of traffic that had caused everything to focus and get into the ukulele or accordion situation it was in. And they say they're responsible. And then they defend the case by saying Williams Brothers needs to be submitted. The
Test. Oh, cool. I can hear myself.
disabled vehicle needs to be submitted, and the driver of the plaintiff's vehicle that didn't get out of the way needs to be submitted. But the only thing the jury can know about, the only thing the jury can be asked about is whether our driver should have slowed down earlier. But we're going to say all these other people are at fault. You know, it is very much a temporally connected causative standard, and it cannot be just extra stuff. That is true in the exceptions as they were drafted by Mr. Parsley himself, by the way, by the constituents that were at the table, and that's what we want to achieve.
Let me ask it this way, but in the second part, the fact that the employer in your example, your real life unfortunate example, that employer would then be identified as having all these other factors in the second phase. And I'm just going to play a little bit of a devil's advocate here. I've heard you say in multiple settings in different hearings, trust the jury. And what I'm getting to is if that evidence is presented in the second part, do you not trust the jury to weigh in on what is compensatable and what's not and at what number? So, you know, it's you either trust the jury all the time or you trust the team none of the time.
I'm pretty uniform in trusting the jury, phase 1 or phase 2. I think there's some members of the defense bar who are available to talk to you today about the challenge of this bifurcation idea. Yeah. Because one of the unique things about this bill, as it was designed, the flower delivery truck, the box truck for a plumbing company, small businesses, they are not affected by this section, right?
And I appreciate those nuances, but I'm just trying to get down to the core of it. At the end of the day, all of the evidence is presented if you have 1 and 2.
But my only point that I was going to make, Senator, was a smaller company that's got a commercial vehicle policy, an auto policy for their company, they don't cover punitive damages. Big rig companies running interstate loads, they do cover punitive damages. Yeah, their tower will.
I think the way the insurance companies work, whether they cover them or not, the cost of everything in their portfolio is amortized over the cost of the ratepayers. So if I have a $100 loss today and I have $100 premium owners or payers, they're going to.
Caught me, brother. Eating some oatmeal, man. Cut me some slack. But that is a good idea. I need to share my action figure here on the live stream. I'm going to fix that. We out. BRB.
I'll put $1 to every one of those. That's just how it works, and then they mark it up for their margins. I mean, insurance companies really have a sweet deal, right? They have a business model that they never lose.
That's true.
So in that regard, it's just a pile on. But I'm just so as a legislature, I can get it. That's how I understand it. First part doesn't let them talk about how bad a guy I was in the past, or some of the culprits that may have been bad actors in the past that have a history. But that does come out in the second part, and jurors get the benefit at that point. They haven't determined how much they're going to compensate, right? The second part's about all of that, and they're going to do it based on all of these facts that you're afraid were not put in on the front end. So that doesn't get lost in that bill, correct?
Well, except for the last part about damages, because they have compensated at the end of phase 1.
Okay, I get you. I appreciate it.
All right, we're gonna, Senator Hinojosa.
Thank you, Mr. Chairman. Just to follow up on Senator Perry's questions. Senate Bill 39, the way it's written, it actually deletes and does away with Section C under Section 772.054. It lists there in detail all the evidence that would be admissible, the exception. So that evidence that's being deleted or taken or omitted, if you will, from the Senate Bill 39, is there any time in the trial itself that you're able to admit that type of evidence? Is that on the second phase of the trial?
It comes in on the first phase of this list is what's admissible for proving negligent entrustment. It's not a list of what's admissible just generally in litigation. And so if the driver was drunk, which is on this list,
Okay.
that is normally admissible in a trucking vehicle accident case, because whether the driver was drunk or not has some evidence of whether he caused the accident. So the drunkenness of the driver, whether the driver's high, that's going to be admissible in a case. Without, you take paragraph C out, it's admissible. You leave paragraph C in, it would be admissible, except it can only be used for one thing or another. But that's admissible. That evidence, all the things in C, if to the extent they are likely to prove that the driver of the truck was responsible for the collision, are admissible.
Well, what about the employer?
That's what paragraph C is talking about, is whether that evidence can be used to prove a claim for negligent entrustment after the employer has agreed to responsibility under respondeat superior.
Okay, so then what is the difference, I guess? We're talking about at what point during the trial is the evidence introduced?
The evidence...
Right now, it seems like it's introduced at the first part. It's a bifurcated trial, introduced at the first part. And from what I'm hearing is that now it'll be introduced on the second part.
Yes, right now, whether the way this thing, because it refers to a whole bunch of Code of Federal Regulations. This is literally true. I can give you the cites if you'd like them. The Code of Federal Regulations then refer to other codes of federal regulations. So you've got this pyramid effect from what that amendment. So today, it may be admissible that the driver was drunk when as negligent entrustment, but under some codes of federal regulations, it would be admissible for negligent entrustment under this bill if the driver was drunk and has been convicted of DUI. Some federal regulations require that he be convicted of DUI. Other federal regulations referenced here in this pyramid don't require he be convicted of DWI. So which is it? Is this law that you've got to be, you can use the evidence if he was convicted, or you can use the evidence if he wasn't convicted? That's the level of things that are kind of out of whack with this amendment that went into the bill. If it just comes out of the bill, what you end up with is that if the driver was drunk or had been drinking, the plaintiff can show that to the jury and say, look, it is evidence that he caused the accident, that he had been drinking.
So if they can show at the trial that the first phase of the trial on damages, you can show that the employer knew that driver had a suspended driver's license or had two other movement violations. Can they show that in trial?
If you take this out, they would not be able to show that at trial if the company agreed to that they are going to pay for the liability under respondeat superior. And that has been the law of Texas since 1961. It's been the law. It is the law in a majority of states in this nation that once the defendant company says, I am responsible to pay the full amount of this claimant's compensatory damages, he was in the course and scope of employment, all those employment-based torts fall out of the case.
Okay, so
Patterson case from 1961.
I understand that. So at what point can you introduce that type of evidence?
In the second phase of the CMV trial to prove that the company was grossly negligent in turning the car over to this vehicle, the CMV over to this person, it can be used in phase 2 to punish the company.
And on phase 1, you do actual damages.
In phase 1, you do actual damages, which don't change based on the company's conduct.
And on phase 2, it's gross damage or gross negligence.
So that's correct. So phase 1, as you know, you've done this for decades, I think, at this point, as have I. Phase 1 damages are compensatory damages. They are plaintiff focused. So if the car crash broke my arm then it costs $5,000 to fix the arm. It doesn't matter if the driver of the CMV was drunk or has a 50-year perfect driving record, it still costs $5,000 to fix my arm. That pain that I received from having a broken arm is the same whether the driver was drunk or the driver had a 50-year perfect driving record. That's the pain. I still feel the same amount of pain. I still feel the same amount of mental anguish. I still miss the same number of days of work for which I'm compensated.
The evidence come in on the gross negligence side,
Right.
second phase.
So reason, once they comp to respondeat superior, they have to pay the $5,000 for the broken arm. They have to pay for whatever pain you suffered. They have to pay for whatever mental anguish you have, for whatever work you missed. They have now said, I'm going to pay that. And those numbers don't change by the badness of the defendant driver's conduct or the company's conduct. Those numbers are fixed based on the plaintiff himself or herself. That's why this rule applies. The admission rule is always applied for the reason that it doesn't change the outcome for the plaintiff. He still gets the same amount of money for his plaintiff-centered damages, and it simplifies the trial for everyone else. So the jury hears a whole lot less evidence that it doesn't need to hear because it is not relevant to any decision left in the case.
So is the objective just to simplify the trial?
Yes, sir. It is
Expedite
simplifies
the
the
trial,
trial.
nothing to do with maybe present bias evidence
Well,
from the defendant's point of view?
So the case law out there across the country, I mean, again, it's across the country. The courts will explain it, just as you're describing. You get a simpler trial. The evidence, the amount of damages shouldn't change. And if the amount of compensatory damages does change, if you get a lot more pain and suffering damage because the person was drunk versus they have a 50-year driving record, that's actually inappropriate. The amount of your pain and suffering should be tied to just what your injury is, not to the badness of the defendant's conduct. So if that number is changing, which is what the plaintiff's lawyers want it to do, they want it to change, they want you to get more pain and suffering damages, the law is that's actually inappropriate. That's what the admission rule says. The only way it changes the outcome of the case is a way that's inappropriate. It changes the pain and suffering damages when it shouldn't.
Thank you, Mr. Chairman.
All right, Senator Hagenbu, and then after that, we'll go to West and then Johnson. So Senator Hagenbu.
Thank you, Mr. Chairman. I want to give Mr. Parsley and Mr. Lucio's opinion on this. The gentleman next to you, they gave you the pretty extreme and recent case where it sounds like a lot of that immediate information would be admissible even after this law. I want you to comment on that. But in practice, what this law is trying to do is there's situations where lawyers are not bringing in to the case just missing some of the immediate stuff. They're bringing in things from many years ago, and not just talking about the exact accident at hand, or even what Senator Perry was talking about, former bad accidents, but even just going into diving deep into the trucking company's policies on safety and saying they didn't follow this policy, didn't follow that policy, and all kinds of other information that they're bringing in, not just immediate things or even information about previous accidents. In practice, they're bringing a lot of other information, pretty much everything they can dig up on a trucking company, and trying to bring that in the first phase of the trial. What they're trying to do is eliminate that so that you can just the jury can focus on the facts. I'd like you both to comment on that, if I'm accurate on that.
99% of the time. So let me first say what happened here with that family is tragic.
Yeah, absolutely.
Heartbreaking. I no words to console them. 99% of the time, they're going to settle that case for maximum value, and they're not going to.
As they should.
As they should.
Yeah.
In the rare case that it does go to trial, if this bill were to pass, you would talk about compensatory damages first in phase one, and liability. And then to Senator Hinojosa's point, in phase two, you could talk about the bad acts of the company. You would still get to the end result of what happens today, but it would be in a way that's more structured and can provide more accurate findings and results in phase one and phase two. That's as simple as I can put it.
And in practice, what's happening, though, is there's a lot of other examples where there's cases where it wasn't so clear, wasn't that extreme case, yet we bring in years and years of information, not just about previous accidents, but all kinds of safety practices, et cetera, and try to make them bear on the first part of the trial, which is supposed to be talking about just the facts of the immediate case at hand and who's at fault, right?
Compensatory damages, again, are to make the plaintiffs whole. What were your expenses? What were your medical expenses? Did you miss work? Are you going to have a lower capacity to make earnings in the future? And pain and suffering. What happens when you introduce evidence that, like I said, and most times is not the approximate cause of the accident, is it prejudices the jury in pain and suffering. Pain and suffering should be more of a mathematical question than, you know, a large subjective jury award. But the punitive side, the punishment side of it, that is where if a company acts poorly, if a defendant acts poorly, a driver, that's where they're held accountable and hopefully deterred from acting that way in the future.
Would it surprise you to hear that if some trucking companies and lawyers would advise them not to have any safety policies at all, so that that in the future, if something like this happens, that a lawyer can't say, well, you didn't follow one of your safety policies 10 years ago, one small one, and bring that into the first phase in the current situation?
It would not surprise me. And there's bad actors in every phase of this, on all sides of this, that, you know, frankly act in a way that put us here today. Whether it's the...
All right, YouTube, we're back at it again. Chatting about some tort reform, some bullshit from my boy Lee Parsley. Let me know if you can hear me in the chat. Got a new setup today. Appreciate everybody who's here so far. I know Hatch is up in here. I'm not sure who our two other viewers are, but comment in the chat. Let me know who you are. I'm going to try to fix this horrible background crap I got going on. But as you can tell so far, Lee Parsley's already spitting some bullshit. Just some straight freaking lies. This is a bill that was already passed in 2021 called HB 19. What they want to do is there was exceptions that were created and added to that bill, and now they want to get rid of all of them. So let's tune back in.
Line of questioning, if I may.
If you have a hearing aid of that size, maybe you should not be a senator. Just throwing that out there. Maybe retire. Maybe let this younger guy behind you, maybe he can take over. Looks like he can actually hear.
In your explanation, Lee, you talked about what's admissible and what's not. If the company, I want to make sure it's clear, if the company does not admit the status of the driver as being respondent.
That's pretty good. I like that. That is why it's called a hearing, Hatch. That's good. Hatch, comment if you can hear me okay, or if you're getting any reverb. I'm trying a new setup today. I noticed in our last live stream you could actually hear my own computer playing the audio through, so just please let me know if you can. Thanks, buddy.
Superior, the company being respondent superior. If they don't admit that, everything that Senator Hinojosa talked about what's admissible, that you said is not admissible in phase one if the company says we're respondent superior, but if they say we're not respondent superior because the driver is not in an authorized status, then everything that Senator Hinojosa talked about is in.
Okay, great. Thank you, Hatch. Hatch, I'm going to try to figure out today how I could add people to the stream. Maybe we could have you join. Oop, I'm done eating breakfast. Let me get rid of that text. Let me figure that out right now. Thank you for joining us, though.
Fact admissible in phase one, is that correct?
That's correct. You have to make that admission. You have to be willing to say, right, that was my driver in the course and scope of employment, and therefore I am going to pay this damages.
Right. And the admission, members, the admission, and again, Lee, correct me if I'm wrong, the admission is not an admission of culpability, liability in the accident. It is the admission, it's called the admission rule, because it is the admission of the company that the driver is acting in the legal scope of their employment. That's why it's delineated as negligent entrustment. But the bill does not affect loading, maintenance, other things. It's simply in the entrustment status of the driver. Is that clear, Lee?
Well, I think our
Correct.
concern, Senator.
Well, hold on. I want to hear your concern.
No, let me cut you off real quick. I don't give a shit what you have to say, Jim Purdue. Let me just suck up to Lee Parsley because he has given me a bunch of money.
Okay, but I want, Lee, is what I said is correct?
That's correct.
Okay. Mr.
And
Purdue.
this, I can leave it to you because I mean, it was Representative Island's point. If that is the intent, and I believe that as the author, you would speak for the intent. And I've heard Mr. Parsley, regardless of these victims and dismissing their damages, say that the intent is to allow that evidence admissible under 053, the exceptions, the legal violations that are causative of the wreck, that a load or a maintenance of the truck, all of that is supposed to be admitted. If that is the intent, then there is a fix that can clarify that intent. Because our concern, Senator, is when you read, and I've heard it kind of spelled out both ways by the other side. The intent is to have the admission rule and no evidence can be admitted if they make an admission, but we admit also that a brake condition or company's independent negligence that violates the law that is causative of the wreck can be admitted. If that is true, then that is admitted to support an independent claim. And the way the amendment works to revise 054A does not recognize that.
I like this guy with the giant camera behind Jimbo. What's he going to do with that? How come he's not taking pictures right now?
Independent claim. So we would offer language to the author. It sounds like it's acceptable to the people who brought you the bill that would make that clear that those causes of actions still exist as exceptions to the rule codified in 054A. And with that fix, this bill can be massively clarified and improved.
And
I'm not going to negotiate your bill, but for Lee Parsley and Texans for Lawsuit Reform, we agree that if it's negligent maintenance, if it's negligent repair of the brakes, if it's negligent loading of the truck, the load shifts and causes a problem, all of that should not be affected, in our opinion, by this amendment. And if something needs to change in the words of the statute to make that clear, TLR will be happy to meet you at the bargaining table and work those words out.
Well, if we don't go to the bargaining table, we say every word is your words and it's not going to ever get changed. But I'm offering something that I think would be
Get him, Jim. Get him, Jim. That's right.
productive, Senator, and we stand ready to do that.
Sounds like y'all are almost getting there.
Let's finish Birdwell. I want to
That was my conclusion. Thank you, Mr. Chairman.
And I,
What Jim's talking about there is that Lee Parsley will not make any concessions, never negotiates in good faith, and the only way he will add an amendment to the bill or a provision to the bill is if it's from his own math. Because he's a narcissistic piece. He's a jerk. He's a real big jerk. But he's also a typical lobbyist. You know, he only wants to hear the words that he comes up with and will not provide any concessions to whatever Jim or TTOA suggests. Which, unfortunately, our democracy, our legislature, was supposed to be a give and take, a compromise. Now it's really just being taken over by the lobbyists, where the lobbyists get everything they want on behalf of the corporation, and the people never get to voice any of their concerns or offer any changes.
Greg, you're about to say something.
Yes, sir. Yes, sir. Senator Birdwell, just one comment. We sat through the Senate Bill 30 hearing the other day, and some of the stuff that we heard was that insurance companies are not taking these trucking cases to trial, and they're settling them without the trucking company's authority or approval, and then they raise their rates because they settled the case, right? We heard a lot of stuff about that. And one thing that medical malpractice has, that doctors have, that nobody else does, is the consent to settle. And if that's not in this bill, but if that's something that should be considered, if that is one of the complaints. And finally, we've been here, well, I was here for 20 years, and insurance rates go up every year on every line of business, no matter what we do. So if this bill is going to change for a reason, I would implore you not to change it because you think that insurance rates are going to go down if you change it. Because until we regulate insurance companies, we're not going to have any control or influence.
That's exactly right. Hey, don't pass this and hope it's going to lower premiums, because it hasn't lowered premiums. It never has, and it never will. But they don't want to deal with the insurance crisis. That's the whole problem here. Is we're going to tort reform into saving and lowering premiums, but it's never worked. I actually pulled up a bunch of research I want to go through today, show you guys during breaks as to how the idea that tort reform lowers insurance premiums has never worked. And this is objective proof that it has never worked.
Influence over that.
I've heard that one before.
Yeah, that's right. I like that. Senator West, yeah, I've heard that one before. Senator West is out of Dallas. I like his tie today. I love a good paisley. I hate this guy's tie. That is a terrible tie. But Royce West looking sharp as a tack.
It seems as though that y'all are almost talking about being able to get some sort of agreement. Let me make certain that people understand. When these cases are filed, is the company a party named?
Yes.
Okay. And if a company turns around, Lee, and admits liability in the first phase, are they submitted in the second phase also, during the punitive phase?
Depends on the findings in phase 1. You can only get to phase 2 for punitive damages based upon the findings in phase 1.
Right. And let's assume that we have the findings to get to the bifurcated portion of it. In phase 2, what evidence can be presented against the company?
Well, so according to the language that was passed in 21, what can be presented in phase 2 has to be different than that which was presented in phase 1. And it goes then to essentially what they're trying to hide from the jury in phase 1 about the company's.
That's right.
So a concrete example, if the driver does not have a commercial driver's license that allows him or her to drive an 85,000-pound truck, which is required by federal law, that is excluded from the jury's knowledge by repealing this amendment.
In which phase?
In phase 1. Because it is the Lucio amendment, it is the amendment that I iterated that law that identified it as an evidentiary exception admissible in phase 1. So when you repeal that section that says if a driver is driving without a CDL, that's admissible in phase 1, that means it's inadmissible in phase 1, and it becomes admissible in phase 2 only for punitive damages. That's exactly what the bill says.
That's just not accurate. It says it's, if you take out paragraph C, it says it's not admissible to prove negligent entrustment. It is still admissible that the person didn't have a driver's license to prove that they are more likely than not the person who caused the collision. That there's a difference there. And what happens in this bill currently is it literally says that if you admit that information as negligent entrustment in phase 1 that he didn't have a commercial driver's license, the jury must be told that it is only admissible to prove negligent entrustment. It can no longer be used to prove that he is the person who caused the accident. Paragraph D of that amendment literally says that. It has to be used for this or that. It can't be used for both.
So the jury would get a limiting instruction?
If this bill is read correctly, that is exactly what paragraph D says. They would have to be given a limiting instruction, told that the fact that he didn't have a CDL is only considered in the negligent entrustment when you're deciding whether and that makes no sense at all. So that's part of this, it just doesn't make sense. But if you just take C out, the fact that he didn't have a CDL, he or she didn't have a CDL, is relevant to whether he or she caused the collision, was capable of driving the truck. Just like whether or not he or she was drunk, just like he or she was over their time in the cab or high or looking at their cell phone.
I haven't tried any of these cases, but President Lucio, you made a comment about pain and suffering being more mathematical than anything. Elaborate a little bit more on that.
Well, pain and suffering in phase 1 as part of compensatory damages. Right. There are experts that have done this so many times that they can provide a more accurate number if the jury isn't influenced at that point with, let's say, bad acts of the company that in some cases aren't the proximate cause of the accident. they will get to one number. If there evidence, for example, whether or not the person had a commercial driver's license doesn't change the pain and suffering of the plaintiff. It's not a proximate cause of the pain and suffering of the plaintiff. The pain and suffering of the plaintiff is his experience with his injury.
Then what caused the pain and suffering? Ghosts? Just freaking ghosts just came out of nowhere?
Now, it should be used for whether or not we punish the company for entrusting or allowing someone to drive one of their vehicles without a CDL, but it shouldn't calculate into the...
Even though the Texas Supreme Court has completely gutted the ability to bring punitive damages in any case, it's virtually impossible. You can't do it, and they know that. They know that. The whole thing is, they never want you to find out. That's the whole goal of this bill. They never want you to find out what the company has done. It's the whole reason for the bifurcation, so it can delay.
Duration, it shouldn't be the determinative factor.
I believe that that's the intent of the law, not necessarily what I feel should or should not be. I think the intent of the law is to compensate them for their pain and suffering, and not include in that portion of the damages punishment of the company.
Okay,
Go ahead.
The problem, Senator West, is that you have the question of liability. So phase one, you have question one. Did the negligence, if any of those named below, approximately cause the wreck? Question two then asks for a jury to compare the fault. So under the scenario that he's talking about, if you hide from the jury that they have a driver that is at 16 hours drive time when the federal regulations limit it to 10, and the company knows it, and the company admits he's their driver, they get to hide from the jury their knowledge that they've got a guy who is sleep deprived heading into a work zone. And then in the second question of phase one, say, put 40% on the company. When the reality is the evidence supports 80%, 90% on the company. And that goes directly then to the measure of compensatory damages at the end of the case. Not the number, but the judgment formation of the number based on the percentages. So this legal fiction that they want to insert in directly affects the way our law looks at comparative fault. That's the problem.
All right, Senator Johnson.
Thank you, Mr. Chairman. This bill as proposed, does it create an incentive for an owner to cop to respondeat superior in order to prevent and preempt exploration of other potential causes of the accident that might not be respondeat superior or the fault of the driver? And are there cases where, you know, we're not really sure if the driver was at fault or it was the bad loading, and the jury needs to explore all of that in phase one of the trial?
Yep.
Don't I have an incentive as an owner to just, you know what, let's preempt our bad loading stuff and our prior knowledge and just...
That's exactly right. Spot on by Senator Johnson.
Cop to the respondeat superior.
There's a concrete example in the precedent in the state law of Texas, a case called United Reynolds, where they put on a flatbed trailer a boom lift that exceeded...
You know, Lee, for a guy that has a budget of $23 million, you have a real shitty pen. I mean, come on, man. Then what is that? This is a plastic ballpoint? Come on, bro.
Height. And the regulations for the company says if you're going to put a height on this flatbed, it's not going to be able to drive certain roads, so you've got to file your drive plan. Company doesn't do it. They send the driver out. He's got a 14-foot high, runs into a bridge, knocks the bridge into a car following, and decapitates the driver behind him. Now, in the scenario of this bill, that company can stipulate that the driver is in course and scope, and the driver says, I didn't do anything wrong. I was driving the route they gave me, going the speed limit. And under the scenario that you offer, the company's responsibility for putting that load on that truck and setting that route will never be submitted. That's what this bill would do. That's
You
say it would be submitted in phase two, right?
No, phase one. That is just wrong. That is in
Phase one, how?
But it is negligent loading of the truck is not You don't, respondeat
the bill
superior
say-
doesn't apply to negligent loading of the
But
truck.
doesn't the bill say that once you say I admit respondeat superior, we're done talking about anything else?
No, it just
Okay.
doesn't, it's
Okay,
just
no,
not-
explain that. It's important.
It's just not the way it works. It's, respondeat superior would be if the driver of the truck was negligent in the way he drove
Right.
the truck. I say he was in the course and scope of responsibility.
But you can be negligent without involving driving.
I'm going to assume that responsibility for paying that judgment. Negligent maintenance, negligent loading is all an entirely different category. It has, and so, again, this entire section of the bill has to do with negligent entrustment of the vehicle. Negligent entrustment of the vehicle does not include negligent loading, negligent maintenance, negligent any of
And
that other stuff.
I'm not going to argue because I think there may be some light here. It sounds to me like there's some light here.
I've already agreed with them on this. If the bill can be read,
and I'll
like they
step
say it
back
should be
because I
read.
think there's some words that could be added to this to make it clear that you're not the bill does not preclude the other causes of action being pursued and findings being made in phase 1 of the trial.
I said that a minute ago.
Y'all
I
are
don't think
smarter
that's
than
what
me.
it says,
I'll let
but
you
if
do
it needs more words to make that clear, I and TLR, Senator Birdwell is the author of his bill. He can choose to do whatever, but I'll sit at the table in good faith as I have every time I've.
He can do what he wants. AKA, he's going to do what he's told. You better shut up until he does what he's told. Because I've paid him plenty of money to do what he's told. Good faith. That's a load of shit. Good faith, Lee. You never showed up in good faith to anything. Probably didn't even show up in good faith to your own damn wedding.
I've ever sat down with DTLA to make sure those words reflect that.
Very much appreciated.
Okay, that's great. Senator Hagenbu?
Yeah, sorry, this may be a little bit redundant. I'll be quick here. Thank you, Mr. Chairman. Mr. Parsons, what I understand is, it's going to follow up that, but what you're attempting to do is not eliminate things that really apply to the loading, the immediate things that happen to that case. That should be included in to figure out who's at fault, right?
Right.
What you're trying, what we're seeing is cases where a lot of much older information is coming in to prejudice the jury against the trucking company. But anything to do, that's what this purpose is, right? It's not, the purpose isn't to try to eliminate or hide information that's pertinent to the accident, loading, the condition of the driver, those kinds of things. Those all are intended in this bill to remain and be able to be used in a trial. You're trying to eliminate things that are truly prejudicatory that don't apply to the exact, to this case at all. Is that accurate?
That's accurate. It's the difference between dependent direct action torts and those that are not dependent. And the dependent direct action torts like negligent entrustment, negligent training, negligent supervision are dependent on showing that the driver of the truck was wrong, was negligent in how he drove the truck. Negligent loading is not dependent on how the driver drove the truck. Negligent loading is itself a problem. So there's a distinction there in the law and in what this bill does, and you're right about that. So I agree with what
Well, if you all can work out language that you agree, where you're trying to do the right thing and make sure that everything's included in the case, determine who's at fault for the facts that happened, including immediate things beforehand, but not include old information that's irrelevant, then I think that's what you're trying to achieve here, and I hope you can work it out together. Thank you, Mr. Chairman.
Sounds like there's a willingness to have a clarifier, for lack of a better term.
There is no willingness. Jesus Christ. Just stick with the way the bill is now. There already is exceptions in HB 19. We already negotiated them.
It's his bill. But members, we also want to point out we have 50 more people who wish to testify.
Oh, that's right.
I'm trying to get through this thing before
50 people, because that's how shitty this bill is.
we go to the floor, so everybody doesn't have to wait and come back. So
I will say, Senator, we stand available, and we will be.
All right, thank you very much. So I know y'all be getting with them. With that, we'll start calling up other people, and I will be enforcing the 2-minute rule, members. Jack Walker.
Here we go. 2-minute rule. It is so unfair. Hey, here's a bill that's going to affect everybody's life. Whoever drives next to a commercial truck. We'll give you 2 minutes to talk about it. We're going to screw you over, but we'll give you 2 minutes to complain, and then we'll ignore it.
Looks like MOYETTLC.
There he goes. Here's Will. Here's Will Moye. Here, my boy.
TLA. Will, if I said it right. Moy, excuse me. Hunter Craft and Jeremy Duke.
Oh, Hunter Craft, let's go.
Jeremy Duke, y'all please come up. I would ask each of you to, that's 4 on the panel.
I'm looking at section 2 of the bill. I see what
I'm only seeing 3 up.
Jim was talking about. Yeah, the portion of the bill to amend chapter 72054 only talks about vicarious liability in terms of if the defendant is operating the truck, nothing else. And there's tons of cases where an action is brought that has nothing to do with the driving, but how the truck might have been loaded improperly or properly. Well, I guess if it's loaded properly, you wouldn't have the wreck. But all right, let's listen to Jack.
This and what you're going to hear today from a number of witnesses. The myth is that lawsuits and runaway juries are the cause of skyrocketing insurance premiums. This is actually a fear-based narrative that we have dealt with for the last 30 years that's actually prompted by the insurance lobby. But it's not true, and it's never been true. So I want to talk to you about some numbers. During testimony today, I expect you're going to hear a number of anecdotal stories from trucking company owners who say, look, we're going to go out of business because my insurance premiums are going up. Everybody in this room is dealing with insurance premium rising. It has nothing to do with lawsuits. But I want to talk to you about the numbers, because in 2024, the property and casualty insurance industry, from AM Best, they made $169 billion in profits. That's up 90% from 2023 when they made $89 billion in profits. That's a 90% increase in 2024. So the insurance companies are making massive profits, but insurance premiums are not going down. The actual drivers of insurance premium problems are inflation, which we're all dealing with, climate change. We've got more and more severe weather-related events. The cost to repair vehicles is up 20% in just 1 year because we have much more advanced vehicles, and they're much more costly to repair. We've got more drivers on crowded roads. These are the drivers that, by the data, is what's driving insurance rates, not not lawsuits. Now, what I would tell you is follow up on what Mr. Allen said a minute ago. For 30 years, we have heard that that if you've passed this bill, that you're going to lower insurance rates. That has not been true, and we've got 30 years of data that show that. Each time this happens, it does not lower rates. Thank you.
All right, thank you. Please state your name, sir.
That's right.
Yes, Mr. Chairman.
Turn the mic toward just so.
Sure, thank you. Apologies for that. My name is Will Moy. I am testifying in opposition to the bill. I have a small trial practice in Houston, Texas now since March 2023. The relevance, though, of my conversation with this committee is the fact that I was a 25-year insurance defense lawyer, 20 years at one of the state's largest and most prestigious insurance defense law firms. I was a member of their management committee, and I tried cases all over the state. I've handled probably as
Now he's on the good side.
much trucking litigation as any defense lawyer in the state over the last 10 years. And I'm going to offer this committee my insight with that unique position in that if it ain't fixed, don't break it. Because there's a reality this bill is built on, it's defense specific. Only the defense can elect to utilize it, and it is an elective exception. And there was commentary earlier about it's dramatically less effective, it's not practically used, and there's a reason for that in the old bill that the new bill is not going to cure. And as a defense lawyer, I'll explain it to you. Now as a trial lawyer. The mom and pop problem is a problem because a defense lawyer has to make an election to, I'm going to bifurcate this case for this mom and pop trucking company, and I'm going to try the first case for compensatory damages. And then I'm going to put a mom and pop trucking company into a punitive phase with no insurance whatsoever. There is no insurance available on the domestic or international insurance market for a mom and pop trucking company. It is available for international trucking companies, interstate trucking companies that are in Phoenix, in Florida, in the Midwest. The reason this bill does not need to be changed because it is used the right way. It is used by the defense bar to protect large out-of-state companies for their internal problems that a jury needs to benefit from. It does not help small business. It hurts small business.
Thank you.
Oh, the timing was perfect. Nice, Will. That's actually, I think, Will's first time testifying in the legislature. That was great. And he's exactly right. This doesn't benefit the small mom and pop shop. The only people that use this stupid exception or rule, which can only be used by the defense, are the giant trucking companies like Swift
Please state your name.
or Benny Keith.
Chairman, my name is Hunter Kraft. I'm a trial lawyer from Houston, Texas. I heard some stories earlier, and I'm disturbed about this mom and pop approach. As I continue to litigate, what I am finding out is these, quote, mom and pops are often foreign companies. For instance, a gentleman from a foreign country living in his basement in Chicago who is hiring sight unseen and unvetted drivers who are driving around Texas roads in the Permian Basin, who recently took the lives as he was high of two of my clients. That is the mom and pop that we are seeking to protect. But what I really
Good point.
want to understand is, what is the problem? What are we driving at? And I keep hearing the term nuclear verdicts. And what I think is important for everyone to understand is what the term nuclear verdict is and where it came from and what its genesis is. It's not in the law books. It was invented by an entrepreneurial defense lawyer in 2021 from California.
What happened to Don't California My Texas? Wow, I didn't know that. Good point by Hunter.
He invented this term, and then he took a trademark out on it and began selling books, selling seats to seminars, and selling software to people so that they could identify this never before defined phenomenon of nuclear verdicts. The people that are making the money off of this craze is a defense lawyer who now has a team that he calls his special forces that he halos into these situations. This whole insinuation of nuclear verdicts are not backed by the statistics. And if there are questions from the panel, I can go into specific statistics. But as we look at TLR's definition, as I appreciate it, for nuclear verdicts, if you look, the fact is that between 2021 and 2025 in the state of Texas, less than 5% of plaintiffs' verdicts, less than 1 in 20 ever meets this, and not a single case has been upheld by the appellate court.
Thank you, sir. Mr.
Exactly right. You want tort reform, you already got it in your Texas Supreme Court. Y'all hear me talk about that all the damn time. Texas Supreme Court has not affirmed a plaintiff's verdict. Even trucking. Let's just talk about trucking. They've never affirmed one. Ever. Past 25 years. Ever, 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 ever. So if you're a defendant and you get hit with a nuclear verdict, just appeal it because you're going to win guaranteed. Guaranteed.
Duke?
My name's Jeremy Duke. I'm from Ennis, Texas. Mr. Birdwell, you're my state senator. I want you to know how this has affected my family. I'm a fifth-generation Texan. We've been in Ennis for over 100 years. In January of 2015, my baby brother was killed by a foreign Canadian-owned Middle Eastern trucking company. The foreign truck driver was intoxicated and backing up on 635 and I-30 in Mesquite, Texas. After he missed his exit carrying a load of avocados, my brother rear-ended him and was killed. I got at the one in the morning phone call that basically they asked me to come down and identify my brother, so I did and had to ask them to clean him up before my mother came in to identify him as well. This caused a great deal of pain in my family from this loss. My brother left behind a wife and a 2-year-old son, and I'm with my family now raising my nephew and looking after my sister-in-law. My nephew doesn't remember his father much because he was 2 when this accident occurred. And I sold my house and I moved back to Ennis to raise my nephew and help look after my aging parents. The effects of this bill are devastating and wrong. My mental anguish is amplified. Actions by this foreign company and driver who is intoxicated, being on our Texas roads, it enrages me to this day. Mr. Birdwell, I wish you would change this bill and protect your voters and stop protecting these foreign trucking companies who are on our roads today.
Boom. Change the bill.
Thank you.
All right, thank you very much. Very sorry for your loss, sir.
I'm very sorry for your loss. I'm not going to change shit. Why? TOR told me not to.
Thank y'all for coming. You're excused.
Thank you.
Thank you. We'll call up the next panel. That's Drew Gibbs, Amy Bolding.
That was a great panel right there. A lot of good testimony, I thought, proving exactly why we don't need this bill, and even heard real world testimony of a guy whose brother was killed by one of these foreign basement trucking companies. That this is who this bill will benefit. We always talk about how we hate China. China's screwing us over. Well, China is operating some of these trucking companies, so don't give them the benefit.
Julie Zandra Cedino, and it looks like Lazandra Cedino. And for those in the audience who are wondering, the members are in other committees. This is all being recorded and video archived. The staff is all here taking notes for their members. And so y'all each heard the 2 minute. When you see the 2 minute, the yellow light, that's halfway through, and when you get to the red one, please stop. So we'll start with the ladies. We'll start on this end first. Please state your name for the record and your position on the bill.
Yes. My name is Amy Bolding. I live in Bernie, Texas, and I oppose Bill SB 39, House Bill 4688. On July 16, 2021, just 19 days after her 5th birthday, our daughter Sadie and her 8-year-old sister were driving with their grandparents through Blanco, Texas. They were coming back from a fun day in San Antonio when suddenly a 40-ton 18-wheeler crossed over the center line and crashed.
Jesus Christ. It's going to kill our kid. It's going to kill our kid. This is who we're protecting.
Crashed into the driver's side of their pickup. Sadie's door was ripped off, causing her to hang out of the vehicle by her seatbelt before assistance arrived. She was airlifted and had to be revived multiple times on her way to the trauma hospital. When we arrived at the hospital, we were told she would likely not make it, and her beloved grandfather also nearly lost his life. The driver of the 18-wheeler told the investigating officer that he had no idea why he crashed into the pickup. Evidently, he was so focused on a cell phone conversation he was having that he unknowingly plowed into my family that was across the road. The conduct of the driver that day was dangerous, it was reckless, and it was also preventable. The responsibility for Sadie's injuries falls at large on the parent company of the driver, as it knew the dangers of driving while using a cell phone, but it did not have safety policies in place that restricted such behavior. Sadie suffered extensive injuries and surgeries as outlined in the handouts received. She has significant scarring all over her body. She has experienced immense amounts of pain, and Sadie will likely not graduate from high school or be able to have gainful employment or have a normal life. Please don't take away a victim's right to hold a trucking company responsible for failing to have safety policies that protect the public. Please preserve a victim's right to have a jury consider all of a victim's damages. Thank you.
Thank you very much. I'm so sorry.
Thank you.
Just please state your name for the record.
I'm so sorry. Why don't you ask her some questions? Why don't you ask her about how this bill would affect her and her family? No, we'll just run through these witnesses, not make any changes to the bill. Why don't you just spit in their faces? Probably do better if you just were honest with them and spit in their faces. Say, hey, I know that this horrible thing happened to your little girl, and she'll never be the same, but TLR gave me a bunch of money.
Mike, over. Yeah, thank you.
Sorry.
Take your time.
Hi, my name is Julie Zandra, and I'm from San Antonio, Texas, and I oppose Senate Bill 39. My sister, Lysandro, is going to tell you a little bit more about my mom's accident, but I want to talk about how it's affected us personally. I'm the youngest of my mom's daughters. She has 3. I'm sorry. And I don't get to have her I don't get to talk to her. She was my best friend. My sisters don't get to have her cheering on her in her corner. And we just really miss her, and it's really, really hard for us to go on with our life without her. And it's really, really hard. She was so important to us, and now we only have a memory of her. Currently,
If you are listening in on YouTube, we are here live on Senate Bill 39 in the Texas Senate, which is the new trucking tort reform bill. We're hearing live testimonies from some of the victims of some trucking cases. There are 50 witnesses that are supposed to testify. They have now been limited to 2 minutes each because there are so many witnesses. Let's not forget that the legislature works for us, but they get to limit our testimony and they don't answer any of our questions. Instead, they will just say thank you, you'll take what you've been given, and we'll take the bribes. Comment below about what you think of some of this testimony, other than it's absolutely heartbreaking. Just, it's horrible. Many thanks to these brave men and women who have shown up, such as these 3 women, to testify as to what happened. Just really, really sad.
18-wheeler. Due to the accident, she suffered a permanent brain damage, which caused her to be completely incapacitated, and she now has to live in a facility to get the care that she needs. She's unable to take care of herself, and she dependent on others to take care of her. Some things that were pointed out in the summary: 3 out of the 4 brakes of the truck trailer were out of spec, and the driver was on the phone for over 5 hours, almost 6 hours of the total 6.5-hour drive that he was on that day of the accident. Just the lack of safety measures of the trucking company that they put on their employees and also on the equipment is just where it just caused my mom to be where she is today. Before the accident, my mom had a really beautiful life. She was the definition of a proud, successful woman, and she was the role model to not just us, but just the people around her. She was a true pillar of the community, and she would be very proud of us for here advocating for her. She would be here too if she could. But now she lives, because of her injury, she has to suffer just constant anxiety, constant stress, and constant pain, and she's just living a life that she would never, ever want to live in. And it's unfortunate that she lives in this nightmare that she can't wake up from. Her medical care alone will cost, she is planning to live a life, but she will need medical care that will cost $17 million. And the trucking company's insurance policy was only $1 million. So we do not want to change laws that hold trucking companies less accountable, especially for the damages caused to Texas drivers. Thank you.
Thank you very much. Drew?
My name is Drew Gibbs. I'm a conservative Republican, former insurance defense attorney, and current plaintiff's trial lawyer, owner of Slingshot Law Injury Attorneys. I'm here to testify against Senate Bill 39, and I will talk about what occurred on March 13th, a travesty in this community. And I'm not just talking about the filing of Senate Bill 39. I'm talking about the 5 Texans that were killed on I-35 at Palmer Lane. You've heard a little bit about that collision. I want to clarify. I provided you a handout. I want to talk about the first phase of the trial under this bill is not just about assessing damages, it's about assessing negligence. And what occurred that day is not just the negligence of Solomon Walkadil Araya, an Ethiopian who had a driver's license for less than 4 months when he killed those 5 people. It's also about the negligence of ZBN Transport, who hired him, and Amazon, who hired him to drive that 18-wheeler. He was not qualified to be behind the road because he didn't speak English. The handout that I gave you gives a video. The first page is a link to a video taken at the scene. You can assess for yourself, did he speak English or not? State and federal law requires that commercial drivers speak English, and it's important that they do, not because we're racist or xenophobic, but because they need to read signs like one that's pictured on that handout. That one says, "The eyes of Texas are upon you," a cutesy sign that we put up during Texas OU weekend. But the sign that Mr. Araya drove past that night is one that would have said something like, "Road construction ahead. traffic stopped ahead. You watch that video, please, and decide for yourself. Could he actually read that sign? He should never have been hired. And when that first phase of that trial occurs, we should know that he should never have been hired by that company. The second thing that's on that page is the arrest affidavit. He was arrested for intoxication manslaughter, something that should be clarified. I don't know why I have 2 seconds left. That's not correct. Something that should be clarified is that he was arrested for intoxication manslaughter. He tested negative for drugs and alcohol. He was fatigued.
I thank you very much. Your time's up. I appreciate it. Very sorry for y'all's loss, really am. Good luck with your mom.
Thank you.
All right, thank you. We'll call up the next panel. Jody Scott, Marie Annette Navarrete, Pontiac, Michigan. Okay. Jessica Sprague and Jason Sprague. Go ahead, please pull the mic over to you. State your name for the record and your position on the bill. I'm missing one on the panel. I had a Jessica Sprague, a Jason Sprague. Somebody still coming? Well, go ahead.
My name is Maria Navarrete. I am originally from Pasadena, Texas, and I oppose Senate Bill 39. On August 5th, 2022, my life, my physical and mental well-being was changed forever. I have lost the ability to enjoy life fully before, as well as lost the ability to be a provider for myself, as I have worked since I was 16 years old. I was violently T-boned by a reckless, distracted driver that had a newborn baby and his wife in his cab when he missed the red flashing stop sign, causing my Toyota Civic to bounce down the side of the 18-wheeler truck, completely smashing my car. At one point, I was airborne, on my whole body lifted up from the driver's seat, and I just screamed, "Jesus, help me." I felt the glass all over my face and arms and felt the impact of the airbags. The next moment, I remember is a father seeing Tom pulling me out of the car and people yelling that there was gas leaking. By the mercy of God, I am alive. To date, I've endured 5 surgeries on my upper and lower back, both knees and one in my hand. That is not including the pain management intervention with blocks in my back for the discs that were completely out of place. Today, I struggle with daily pain and struggle with driving a car due to PTSD. I can no longer work to provide for myself and was eventually put on disability, full disability due to my injuries. I am thankful for our current law allowing me to hold this person and company responsible for my life-altering changes. Changing this law would ensure that my rights or a hurt individual's rights would greatly be diminished, causing more harm. I pray for your compassion.
Thank you very much. I'm very sorry for your situation. You must be Jessica. Yes. State your name, please.
Good morning. My name is Jessica Sprague, and this is my husband, Jason. This is our son, Colton. We are from Houston, Texas, and we oppose Senate Bill 39 because Colton was killed when a truck driver ran a stop sign and T-boned our vehicle. That truck driver had a history of drug use and never should have been behind the wheel that day. July 24th, 2022 was the worst day of our lives. That was the day we lost Colton. I remember my husband screaming Colton's name as he tried to save him. It felt like an eternity at the hospital. As the doctors worked on him, he was going to be life flighted to another hospital, but his vitals crashed. We watched him get carted to and from the helicopter. Eventually, Colton had been given as much medicine as possible without it becoming toxic to him, and ultimately he passed at 2:02 that afternoon. He was 16 months old. Through our case, we learned the following. While we were trying to save Colton, the truck driver received text messages from his wife about getting urine for his post-accident drug test. The driver beat his drug test because the company allowed him to go home and provide it the next day. And the driver was fired from his last employer for refusing a drug test. But the company still hired him because they did not follow the regulations for investigating the driver's background. These horrific facts paint a stark picture of just how tragic yet preventable our son's death was. This bill would have prevented a jury from knowing why we really lost our son. They would have only heard about a man who ran a stop sign. This crash was not just about a man who ran a stop sign. It was about a company who never should have employed that man in the first place. If a company can hide from that truth, they won't get any safer. On the 2-year anniversary of the crash, we welcomed a baby girl. She will never get to meet her brother here on Earth, and we will never know the amazing big brother Colton would have been. Thank you.
Thank you.
My name is Jason Sprague. I'm Colton's dad. And I oppose Senate Bill 39. When I don't have anything written out, but just being here today and listening to the people that were up here and talking about insurance prices, and then they leave the room whenever the real victims are coming up. And I know that we have representatives here and people here taking notes, but whenever the rest of the people also leave the room, whenever we're telling the real world stories, that does not make me feel like our voices are being heard. Thank you.
Thank you. Very sorry for your son's loss. You must be Jody.
My name is Jody Scott, and I'm here with my daughter, Aubrey Scott, who is 13. I have lots written down, but I'm not quite sure I can get through all of it. Back in September of 2015, my husband lost his life. A trucker ran into my husband's Camaro, who was behind a gas tanker truck, and they were stopped to let a school bus release kids on the opposite side of the road. This truck driver with CKJ Trucking did not see everyone stopped for the school bus and ran right into the back of his Camaro, and he was killed instantly. This trucker should not have been employed. I don't know if I'm going to get through this.
Take your time, take a deep breath.
CKJ CEO Jonathan Cranmar was chairman of the Texas Trucking Alliance in 2021. When this original bill was passed, Jonathan Kramer, the CEO that was responsible for my husband Donnie's death, has led the charge for this bill, which shields their bad conduct for injuries and prevents true accountability. This bill raises significant concerns about the safety of our communities. It seems to allow dangerous companies such as CKJ to invade responsibility for the tragic consequences of their actions that can have on us Texans. If passed, it could prevent us from fully understanding how unsafe practices lead to accidents that devastate families and harm our communities and our roads. Thank you.
Thank you. Very sorry. Thank you all for being here.
Thank you.
Call up Robert McCart, Bradley Pearson, Melissa Traylor, and Autumn Owen. Sir, you were first. Go ahead and please state your name for the record and your position.
I'm Bradley Pearson. My wife Leslie's with me today. 9 days ago was the 5th anniversary that we lost our 28-year-old only son. It was the worst day of our lives. He was on his way to our house to visit us when a cement truck driver turned left in front of him, hitting him head on and killing him instantly. He was on the cell phone. He was also a convicted felon. Our attorney found out he'd been on the phone 55 minutes when he hit our son. He claimed he'd never saw our son, which is textbook inattention blindness. They proved his cell phone talking was habitual. They overlapped his cell records with his driving logs, and him and a fellow driver, which both knew it was against company policy, in the previous 90 days had 150 plus phone calls between the two drivers. Burnco admitted they didn't enforce their no cell phone policy.
All right, y'all, we are back. Sorry about that for a short delay. But back, we're listening to testimony. Not sure what these folks are chatting about, but happy to be back. Looks like we got 3 people joining on the live stream. I love that. Thanks for joining in, guys. Thanks for listening in. Really appreciate it. Let me know in the comments what you think of the testimony so far. Hopefully I can get some more lawyers to join in to the live stream today. I've sent out a couple texts, get some feedback. Let me know what you guys want to hear, what you want to talk about, what you think, what you feel. That's what makes it more enjoyable experience, I think, for everybody. Again, we're here talking about SB 39, new trucking bill, and witnesses testifying for and against the bill. I might skip through or speed up this testimony so we can get closer to the live action. There's also another parallel pending bill in the House, so we will jump over to there at some point, see what the Judiciary Committee.
There's an active investigation going on.
Judicial compensation. So we'll stick with trucking for now, but I will continue to update everybody on what's going on in the Judiciary Committee hearings. Thanks for tuning in. We'll speed up this testimony right here so we can get closer to the live portion.
Employers like Burnco cause the death and mayhem on our roads and destroy families in the initial phase of this. If passed by you, this bill will allow dangerous companies that don't enforce their own safety rules to escape full responsibility for killing and injuring Texas. It puts all of us in danger. This could happen to any of us on the way home today. Nobody's safe. So thank you for your time.
Thank you. Sir, please state your name for the record.
I'm Robert McCart, speaking against Senate Bill 39. I'm not going to bore you with the long tragic story of my wife and how our lives have changed. I'm not going to bore you with the long history of this driver who should have never been on the road. I'm kind of a simpleton. I fail to understand how a bill that puts up another wall in the legal process that I have to climb protects and serves me, the rest of these folks, the state of Texas.
Right, great point. I love that. I love that perspective. How does this help me or my Texans by adding more laws? It's a really good point.
This bill is designed to protect insurance companies and trucking companies. I believe the gentleman over here earlier today said the insurance company never loses. The idea that this is going to lower our rate or make our life better, non-existent. Do what is right. Do the right thing for your citizen, for your constituent, and for the people in this room.
Right.
Thank you.
Thank you, sir. Please state your name, ma'am. No, first,
Good morning, and thank you for the opportunity to speak before you today. My name is Melissa Traylor. I'm the
People applauded and they said, no, pause. Shut up. We don't care what actual constituents have to say. We only care about TLR's money.
widow of Officer Andy Traylor. I am in opposition of Senate Bill 39. Andy and I met in 2003 while he was in the Navy, where he served honorably 10 years as a submariner. We had 3 beautiful kids in that time. After his time served, we moved to the great state of Texas, where he ultimately pursued his dream of becoming a police officer for the city of Austin. On July 13th, 2012, he was sworn in as a peace officer. To Andy, this wasn't just a job, but a calling. He was born for this position. After babies, 9 whether that's
I'm Owen. I am a defense attorney, and I operate primarily in trucking accidents, and I am in support of Senate Bill 39. I first off want to say I sympathize with all of the testimony that you've heard today.
She supports the bill. Okay, let's see. This will be interesting. Defense lawyer in favor of the bill. I'd like to hear what she has to say.
About these horrendous accidents. However, what we're here to talk about is the bifurcated trial and whether the current structure is appropriate. The intention of House Bill 19 was to have the bifurcated trial so that the cause of an accident as well as the compensatory damages were decided in the first phase.
That's what's happening. You got what you wanted.
Everything after that, what was intended to punish the driver, the trucking company, that is for the second phase.
Which you already have if you're seeking punitive damages. So, what's your point?
It goes exactly with what Senator Perry had mentioned about how we handle it in our criminal system. In order for
let's compare it to the criminal system with a completely different burden of proof. That makes a lot of sense.
For individuals to get a fair system, they need to have a fair shot. What is important in the first phase?
They're not citizens, they're corporations.
Is what caused the accident, not the ability for plaintiffs' counsels to have smoke and mirror showing that some ticky-tack, they didn't file some kind of application when they started employment.
Why would I, as plaintiff's counsel, bring up ticky-tack? regulations or rules that don't help me prove my case. Seems like a waste of time. Seems like a great way to piss the jury off, because jurors love when you waste their time. Not. They get angry. They want to get out of there.
Negates the fact that their client may have ran a red light. And I'm not saying that that's the stories of these individuals. The issue here is that currently, as it is written, the statute allows plaintiffs' counsels to attack not just these $80,000 or 80,000 truck companies, as you heard earlier. My clients are not these Middle Easterns in the basement. They are small trucking companies, and they are getting hit with the exact same negligent entrustment claims as these huge companies and getting nailed to the cross.
Because they commit negligence?
For essentially having a company and trying to do their best when we've already admitted that our driver was in the course and scope, we've already admitted fault, and we just want to pay what's fair and reasonable. It prejudices my client. It's not fair. And as the bill is currently written, it would make this a fair trial.
Senator West, I think, wants to ask the
At
question.
all due respect, I've practiced a little law in my time, and juries can take into consideration in criminal cases what's been introduced during the case in chief, during the regular case, and also take that into consideration during the punishment phase. So whatever evidence is admissible during the first phase of the trial can be considered also by the jury in the second phase of the trial to determine what the punishment should be.
It's certainly possible. However,
it's not possible. It is. They can do it.
Well, and respectfully, Senator, what we're seeing is we are seeing the unprejudicial effect on clients. I'm sorry, the prejudicial effect that it has on trucking companies to have this information presented when it's intended to be a bifurcated trial.
No, I understand what you're saying, but to make a statement that it cannot be considered or should not be considered in criminal, you referred to my colleague Senator Perry. I didn't say anything to him because I just wanted to move it forward, but I can't let it continue to move forward without addressing that. And what I'm saying is that in criminal cases, a jury during punishment can take into consideration what was introduced during the case in chief. That's all I'm saying.
Understood.
All right. Thank all of y'all for coming. Very sorry for your situations. Call up Ronald Baer from Montgomery, Texas. Victoria, looks like Lemon from Buda. Gary Spring from
litigation. I want to speak in favor of eliminating the evidence on the issue of negligent entrustment.
This guy on the left was at the Senate Bill 30 testimony. Really powerful. Oh my God, he was one of the best. Talked about his daughter being killed. Just gut-wrenching testimony. Really, really. He's represented by Mr. Cherry, plaintiff's lawyer out of Waco. Really good lawyer.
Entrustment in phase one of the trial. The objective of the statute is to simplify the core decision that has to be made in a trucking accident, which is of the two drivers that are involved, who caused or contributed to the accident, and in what percentages. If you go beyond that inquiry and you start bringing in evidence of negligent entrustment, it's like trying to put a square peg in a round hole. It's going to confuse, muddy the water with respect to the consideration of the fault of the two drivers. The jury just simply needs to determine who caused the accident as a result of the conduct of the two drivers, not any evidence that comes in with regard to negligent entrustment. Now, having litigated hundreds, if not thousands, of these trucking cases, in my opinion, the only reason plaintiff's counsel would want to admit evidence of negligent entrustment in phase one of the trial would be an attempt to demonize the trucking company and then hope that that would have a carryover effect when the jury has deliberation with regard to the fault of the drivers, and that would not be appropriate in terms of trying to have a just and fair trial. That would interfere, in fact, with the core intent of our judicial system, which is to have a verdict decided directly and simply on the facts of the case. There's no harm to the plaintiff without negligent entrustment evidence in phase one. The percentages of fault will still be decided and applied to the damage findings, resulting in a judgment reached with a fair consideration of the evidence.
I do, and thank you very much for your testimony and your experience in this area.
Yes, sir.
I haven't tried any cases in this area. As it relates to a hypothetical that was given by earlier.
Yes, sir.
If a driver is driving a truck, did not load the truck, but it was loaded by the owner of the company under their directions.
Yes, sir.
And they run into overpass. No negligence on their part. And the driver's doing what they're supposed to do. How do you then make sure that the jury knows that, as it relates to apportioning liability compared to negligence, that you would ding, if you will, the driver of that truck? When in fact, it's actually the company that loaded the truck. How does that work out?
I'm glad you asked that question. There's actually two parts to that answer. The first part of the answer is that, according to Lee, that evidence would still come in with regard.
According to Lee Parsley. Well, he's not a lawyer. Well, he did graduate law school. He's not a practicing lawyer. I guess he is a lawyer, though. Sorry.
The cause of the accident. The second part of that
is a separate cause of action against the company?
Yes, in the first. But the second part of that is that a driver has a responsibility to do a pre-trip inspection of his truck and be knowledgeable about the route upon which he's going to travel. So that evidence would come in and should rightfully be considered then with respect to the fault of that particular trucking company driver.
And also the independent cause of action as it relates to the failure to load the truck right and all that other stuff against the company would also come in the first phase of the trial.
It's my understanding from the testimony this morning, and it's
Based
important.
on your experience.
Oh, absolutely. And also, you need to put into perspective the negligent entrustment part of.
Why would it come in if it's not in the operation of the vehicle under the plain language of Section 2? I think it was. Yeah, it's not operating the commercial vehicle. They're going to say it's loading the vehicle. It's not operating, so that shouldn't come in the first phase. But when does it come in? I mean, when does that claim for improper loading come in at trial?
This consideration. It truly is putting a square peg in a round hole, because you're bringing up issues with regard to the trucking company's responsibilities with regard to how to properly, vet a driver for driving. When that happens.
Well, yeah. If you had properly vetted the driver, maybe the crash wouldn't have occurred.
Typically, in my 43 years of experience, the plaintiff's lawyers want to, and I can't fault them for trying, expand the scope of that inquiry to not just the driver involved in the accident, but other drivers of the trucking company. And it just keeps getting bigger and bigger. You back up the truck, you load that into phase one, pretty sure.
Well, then go file a motion. File a motion for protective order. If they're seeking discovery that isn't relevant, file a motion.
Pretty soon the jury's confused as to exactly what their job is, which is to say who caused this accident. Not issues with regard to negligent entrustment.
Thank you, Mr.
Thank you. Please, sir, state your name for the record.
My name's Gary Spring from Austin, Texas. I oppose this bill, Senate Bill 39.
Well, we've seen a lot more opposition to this bill than we did in SB 30 so far. Only two for the bill that I've seen so far, excluding Lee and then also the bill's author.
I'm here today because I lost.
Okay, thank you, members. Any other questions?
Let me just share with you some of the facts about that case. The driver was a 69-year-old man coming off of cancer treatment who had no trailer experience.
Also, just a quick update for the House Judiciary Committee. It looks like they're still talking about judicial discipline, so we'll keep it here on the Senate.
I have no problem with that. The driver was never road tested by the trucking company. He'd never been given a road test even. At the time of the accident, the corporate office of the trucking company was on the phone with the driver, telling him to come across the street to get his check on Friday instead of turning right and going and delivering his load. At the accident, DPS told the owner of the trucking company to take the truck directly across the street and park it and secure it because there's evidence there. There was a dash cam, everything. The truck was taken across to a lot, and was it secured? No, the dash cam was immediately removed. Lo and behold, we had to go through all kind of court proceedings to even get them to acknowledge that there was a dash cam. And by the time we got it, the dash cam was professionally deleted.
They deleted the dash cam. What? Defendants committing fraud? Hiding evidence? You heard SB 30. Only plaintiff's lawyers do that. Interesting.
Luckily, we had other video evidence from the scene from the store.
44 pre-K students, 4 and 5-year-olds, which included some of our deaf education students and some of our special education. Our bus flipped. We hit every single side of the bus. Glass cut my body, cut my daughter's body. I fractured my back in 4 different places. When the bus stopped, all those kids who had fallen asleep on the bus were screaming, crying, blood pouring off their face. They had no idea what happened. You hear in their faces, Rodriguez Montoya, one of our students.
Look at this defense lawyer. Look at this. You know he feels like shit sitting next to these 3 people, knowing he testified supporting a bill that screws all of them over.
Was laid lifeless on the ground. He never had a chance. He never made it home. Knew there's 40 life.
2nd, 2023. My 19-year-old, Seven Texas.
Yeah, thank you. That's a terrible story. Thank you. Yeah.
Terrible. It's a terrible story. Terrible story. But I'm going to vote for the bill because I've been paid by TLR. Chair
Please pull
Nichols,
the mic around. Very sorry.
let's take a look. Let's take a look at how much money Chair Nichols has made from TLR.
My name's Ty Turkett. I live in Valley Mills, Texas. On September 22nd, 2023, my 19-year-old, 7.5-month pregnant daughter was advised to go get her teeth cleaned just down the road. Her mother wanted to go with her, so me and her mother were at the entrance of the ranch, waiting for her. She slowly come to a stop there in front of us and was 60 feet from us, looking out the driver's side window right at us. All of a sudden, 80,000-pound semi-truck pulling pipe heading to Midland, Texas, appeared behind the oak tree. He had 10 seconds to stop that truck. The sun was at his back. Jesse James couldn't have asked for anything more. He had clear line of sight. He didn't hit her. He ran over her. They should have been caught by the broke.
This dad he's crying, man. He's crying. And at any moment, these senators could stop and say, guys, we ain't doing this. We ain't putting this people through. Let's keep the losses sin. No, let's make them suffer. Let's make them all sit here and suffer and retell all these horrible things that have happened to their family. It's just awful.
Brokers. There were multiple things. Me and her mother I pulled her out of the car, laid her on the asphalt, and started resuscitation until some help got there and care lift got there. She was care lifted to Baylor, Scott, and White in Waco, and they did an emergency C-section. She passed away 3 days after the accident. The baby survived, but she has damage. The umbilical cord went acidyne because Emily had died on the scene, and the baby has severe brain damage. So we've been living in severe damage or catastrophic for 18 months now. It's only going to get worse on these highways, and I oppose Senate Bill 39, and I oppose Senate Bill 30.
All right, sir.
Thank you.
Thank you. Thank all of y'all for coming. We really appreciate you being here.
Oh, can I show you a picture?
You can leave a picture with her. She'll share it with us.
That's 3 days before the accident.
All right, thank you, sir.
Can I show you a picture? No. I said no.
Call up Lori Villa, Edinburgh, Laura Tenez, Texas trial lawyers, Ashley Sibley, and Ashley.
Oh, what a shock. Chair Nichols has taken money from TLR. I'm going to live share this as an image on the screen. Oops, doesn't look like I can. Hold on,
Looks like Mulkey, M-U-L-K-E-Y, from, looks like Alton. Looks like Louisiana. Anyway, that's 4 called up. So you're first, ma'am. So please go ahead and state your name for the record.
Yes, my name is Laura Tamez. I am former president of the Texas Trial Lawyers Association. I was vice president of legislation.
Laura is awesome. Used to be president of TTLA. She's really, really good. As I was saying about Nichols,
Affairs in 2021,
Nichols
and as part of
has taken $15,000 last year from TLR. The guy who was testifying earlier in favor of the bill, talking about the guy who drafted the bill that Jim Perdue was sitting next to, chair's taking $15,000 in bribes from him. So you really think he's going to take into consideration the picture of that guy's daughter, whose testimony we just heard? Hell no.
will be adjudicated by a civil jury. So all of the evidence that could have caused the crash, for example, if a trucking company knows that there is a driver who has 5 DWIs in their history, true story, that has 3 convictions for reckless driving and speeding, that has failed toxicology screens repeatedly, those are the bad choices that a company makes, aside from the negligent loading. But the choices they make the day before the crash, months before the crash, years before the crash, that specifically govern the crash or cause the crash should be adjudicated by the jury. Our mandate was to protect good companies and punish the bad companies. But stripping out the exceptions to the rule, you lose the guardrails, guidelines, and framework for the judiciary. And yes, thank you.
So please, Senator West.
Laura, thank you very much for your testimony. How many appellate Supreme Court cases have there been since 9/1/21 when this law took effect?
None. There has been a first court of appeals case, and I'm a practitioner and have been for 30 years. And I've tried one of these cases under the new law of Chapter 72, and have gone around the state with defense lawyers so that we can present how to try a case under Chapter 72. The only case currently is a first court of appeals case where the judge went outside of the code and may have been looking at the conflict of authority that had existed before this statute was enacted. That took away the conflict of authority, but the judge did not read the code in the manner it was written. First Court of Appeals told the judge, you have abused your discretion, and that case needs to go back to the trial court. So it is working. Good trial lawyers are able to litigate these cases both on the defense side, both on the plaintiff side, because the guidelines give the judges no discretion on how to try the case, when the trucking company is going to be in on the line. But the exceptions being pulled out of that, the judge now loses those guidelines and guardrails, and good companies may have to be forced to the gross negligence phase.
Thank you very much.
Thank you. So we'll go ahead. Please state your name for the record, ma'am.
My name is Lori Vela. I'm from Edinburgh, Texas, and I'm here to strongly oppose Senate Bill 39. On December 29, 2022, my husband David was killed in a crash that should have never happened. A truck driver pulling an extended gooseneck trailer made a reckless left turn in front of him. The trailer had no lights, a reflective tape that was damaged, nothing that would make it visible to oncoming traffic. It was being driven after dark with no escort and by someone who had never been properly trained by his company. My husband didn't have a chance to react, and in a moment, he was gone. That night, I was waiting for him to call and tell me that he had made it back to his hotel. But instead, I got a call from someone telling me he was involved in a car accident and he didn't make it. My kids were standing around me wondering why I wouldn't stop screaming, and that's all I could do. And that moment changed our lives forever. I became a widow, and our 4 children lost their father. My daughter spent her senior year of high school grieving, and my baby, who was just 1, still asked if her daddy is coming home. My 2 boys, they still needed their dad. He was supposed to teach them, guide them, play football, take them fishing, and now they have to grow up without him. Because of the laws we have in Texas today, I was able to hold that company accountable.
All right, we're back.
Those laws gave me access to the truth that the driver had been.
Thanks to everybody who's joined the live stream. We're hearing more and more testimonies so far. Really powerful. Really, really powerful. Got to also just hear from Laura, who's always doing a really great job. Heard from Jim Perdue, Hunter Craft. Tons of witnesses. Trying to get some people to join. I think Hatch is still with us. He had to, actually he's not with us, had to step out and go to a business meeting. Looks like Royce West is leading the hearing. Let's tune in and see what this testimony is.
Because families seeking justice need to hear need the jury to hear all the facts when deciding who is at fault, not just the facts the company wants the jury to hear. If the trucking company that killed our husbands had tested for drugs or audited logs, we wouldn't be here. This bill would take away the right of victims to hold companies accountable for not following the law.
All right, if they were following the law, they wouldn't need this bill. Damn. If they were following the law, they wouldn't need this bill. I love that. I'm gonna drop that text right here. If trucking companies were following the law, they wouldn't need this bill. God, ain't that the truth? I mean, that's a really great point. I mean, why are they here? What are we doing here? If these trucking companies are so good, doing everything right, why is it that I have to come testify about my dead family member, or about why we need a different set of rules in trucking? I'm gonna put that right at the top there. I love that she said that. That's a better point than some of the lawyers have made so far.
It was pure torture to watch our children lose their daddies. Through our own deep grief that day, we had to sit down our 6 babies, ages 6 and under, and tell them their daddies were killed. It was only a few minutes after this that my daughter Millie noticed Corey's daughter Ellie crying. She gave her a hug and gently cupped Ellie's cheeks with her tiny hands and uttered the most innocent words I've ever heard. "Don't worry, Ellie, daddies always come home." You see, they had never known a world in which their daddies didn't come home, and it shattered my heart into a million pieces to correct my daughter and tell her, this time daddy isn't coming home.
Thank you. My name is Ashley Webb Sibley, and I'm against SB 39. As you can see from the handouts we gave you, the driver that killed our husbands was under the influence of drugs.
Well, it's both of their husbands died in the crash. Jeez. They're so young, too.
And over his hours. And this ultimately led to him falling asleep at the wheel. Our husbands were doing nothing wrong. They were at a complete stop, waiting for another 18-wheeler ahead of them to make a left turn, when they were hit by this driver at 69 miles per hour on cruise control, and never hitting the brakes and killing them instantly. What we could never do in under 2 minutes is explain to you how much these men meant to us and to the world. They weren't only husbands and fathers, but they were sons, brothers, cousins, friends, and so much more. Their loss affected every person that knew them and loved them, and we will do everything in our power to help minimize these tragic, unnecessary losses due to negligence. This starts with accountability. Taking away accountability will only lead to more negligence and more stories just like ours, with more children being told that he isn't coming home. Also, silencing victims and not allowing their full stories to be told in complete truth is unfair and unjust. When you consider this bill, I urge you to think of us and our children, and remember that the safety of our own family and friends is at stake. We respectfully request Texas to reject SB 39 and HB 4688 and support victims like our families.
Thank you very much. Very sorry. Thank you all for coming.
Very sorry.
I'll call up the next panel, Lauren Robinson.
Very sorry, but the $15,000 I took in bribes are really easy to listen to over your testimony.
Call up the next panel, Lauren Robinson, Dale Robinson, Whitesboro. Looks like Robinson. That's your writing. Robin, S-A-B, or Robinson. Whitesboro. That's Robinson. Henry Contreras from Northlake. You were first, sir. Go ahead and pull the mic over. State your name and your position on the bill.
I am Doc Robinson, and I'm against the bill. I have a unique situation. I own an excavation company, and we had commercial trucks. I am Doc Robinson, and I'm against the bill. I have a unique situation. I own an excavation company, and we had commercial.
This is a guy who owns what would be categorized as a trucking company, and he's against the bill.
Trucks. As a company owner, we only hired drivers with a good safety record, drivers that had a 2-year medical card, did everything that we could to make sure people we had on the road were always safe. And I feel like if we could do that as a small operation, everyone else can do the same. April 5th, 2021, I lost my brother and niece due to a commercial driver. He was driving a trash truck. Driver fell asleep, crashed into an onslaught of cars that were parked behind the school bus. And April 6th, just personally, I went to go to where, they have the coroners down there in Dallas, and I went to go pick up my brother Casey Robinson, my niece Brindley Robinson, 6 years old. My brother was a Salina police detective, so I went down there with his brothers and sisters in law enforcement, and I personally brought them back. But seeing firsthand what commercial vehicles can do, it made me, I guess, more confident in my decision, being extremely picky on how we hired drivers in our
So it worked.
situation.
The lawsuits worked. He said, my guys didn't do anything wrong. But I hear about all these bad drivers, and I'm now extra careful on who I hire. It's the whole point of lawyers.
That's all I got.
All right, thank you.
My name is Lauren Robinson. I'm from Whitesboro, Texas, and I oppose Senate Bill 39. As Doc was talking, on April 5th, 2021, the worst day of my life, 4 years ago as of Saturday, my family and I were involved in a trucking accident. We were rear-ended by a fully loaded trash truck going 67 miles per hour as we were at a standstill behind 3 other vehicles that were behind a school bus full of kids unloading them. My husband, Casey, of 15 years, and my 6-year-old daughter, Brindley, were killed instantly, and I was critically injured. I was care flighted, and I spent 8 days in the hospital.
Jesus.
He was a Salina police officer, and that was his passion, and it would just literally kill him to know the standards of the trucking company when he was one of those that made sure that they did what they were supposed to do. I had 3 months of physical therapy, and at this point, I still have medical issues 4 years later. I had a traumatic brain injury. I'm no longer able to work. I lost the love of my life. I lost my future, my daughter. I'm an orphan myself, and so I have no immediate family. Because of what happened on April 5th, I'll never be the same. It's changed my life. I would not wish this on my worst enemy. My livelihood has changed. I can tell you Texas needs safe roads, and if this bill passes, it would make it harder to hold trucking companies responsible when their negligence leads to serious accidents like the one I was in. Ultimately, if this bill passes, it would limit justice for victims of trucking accidents like myself. I feel this bill actually lowers standards for trucking companies, when in fact, I feel like the standards should actually be higher than they are now.
Thank you very much. I'm very sorry. Sir, please go ahead. Sir, please state your name.
My name is Dale Robinson. I'm against this bill. Casey was my son. Brindley was my granddaughter.
Jesus.
As I started our company nearly 50 years ago with integrity and honesty and reliability to be taking account for everything we did. And as my son stated, we sold those trucks within a year and a half after this accident because I don't want to be putting anyone else in this position.
I don't want to be part of this industry. Damn.
The grief is real, the devastation is real, the finances. As my daughter-in-law told you, you don't lose one income, you lose two. They were just in their new home for 4 months. How do you survive this when you take away victims' rights? Only thing I could tell you, all of you need to think about God.
There we go. Oops. Oh, wait, what is the stream here? Oh no! The stream is broken. Oh no! Ah! My friends! lens is broken. Whoops. Okay. Let's take a break.
And I couldn't comprehend how this could be allowed. Now you can see what
Oh, we're back. Okay, sorry about that little snag. Apologies. We are
this
back.
pain has.
Let me know if you can still hear me. You can still see me. Comment in the chat. About one viewer, I think that's probably a Hatch. Comment in the chat if you can still hear us and see us. If you see the words on the screen, this is live testimony that we've heard so far. Really powerful quotes here. If the trucking companies were following the law, they wouldn't need this bill. I would never wish this upon my worst enemy. These are victims, families that have been in these horrific truck crashes, knowing that this bill should never be passed. Or just follow the bill, follow Chapter 72, what's on the books. You already passed this bill. Quit putting these people through it. These people are down here in Austin crying, 10 o'clock on a frickin' Wednesday. Just pull the bill. Jesus.
Inflicted on me, from ashes to dust and sadness to sorrow, there has been no change. This wound is still open, my emotions unspoken, her death has taken a toll on me. With emotions like these, I beg you please vote against Senate Bill 39.
Thank you. Thank all of y'all for coming. Very sorry. Very well. Call up the next panel, Cynthia Gear, North Lake, Nicole Mackledorf, Navasota, Jordan Monk, Baytown, and Tricia Graham, Nevada, Texas. And so, ma'am, if you'll go ahead and pull that mic up to you and state your name for the record. And begin your testimony.
Good morning. My name is Cindy Jared. I am here today with my husband, Juan, and our granddaughter, Emery. We are from North Lake, a small town north of Fort Worth, and we are here to oppose Senate Bill 39. On the morning of February the 11th.
How many more people do you need to testify against the bill? We haven't heard from one trucking company. We also haven't heard from? Haven't heard from anybody in the insurance industry saying this bill will help lower premiums. Remember the bill's author? He brought up that these nuclear verdicts are driving up premiums. We haven't heard any testimony. We haven't heard from anybody in the insurance industry. No one has come forth to verify that that's true at all. Unbelievable.
11th of 21, while on her way to work at the Tarrant County Court, our beautiful 34-year-old daughter, Tiffany Jared, was killed when an inexperienced truck driver pulling a trailer for FedEx carelessly plowed into her car. Not only was the driver not using caution on the icy toll road when he slammed into Tiffany, he was driving so fast that the truck and the trailer ran over the top of her car, killing her on impact. As a mother, it crushes my heart to know that Tiffany did not have time to escape the car, and I could feel the fear and the helplessness that she must have experienced in her final few seconds as she looked back into her rearview mirror and saw the 18-wheeler coming straight at her. We were never able to say goodbye or to see her again or hold her hand or kiss her cheek. That was all taken from us by someone who failed to uphold the standards of training and safety protocols set by truck drivers. That morning, we lost our only daughter. Our 4 sons lost their sister. And at the young age of 11, Emery lost her mommy. That day in Fort Worth changed our lives forever. We long to see her beautiful smile again and to fill the void that she has left behind. Tiffany had the biggest personality and was full of life, and it was all taken from us in a matter of seconds. With the laws that are in place today, we are currently in the process of holding accountable not only the drivers, but the FedEx Corporation and all the trucking entities that have displayed substandard training for their employees, negligence, and the lack of upholding policy and safety. Our daughter's death changed our lives forever. Victims and their families should have the right to hold these companies accountable when their negligence causes death or catastrophic injuries to their loved ones.
All right, thank you, ma'am.
Thank you.
Are y'all all with her? Or? Okay, all right, please go ahead and state your name, ma'am.
Hi, my name is Trisha Graham, and I oppose Senate Bill 39. I am the wife and now widow of Captain James Bull Graham, a beloved husband, father, and fire captain McKinney, Texas. Jamie served this community for over 24 years, saving lives and protecting families. But in 2023, our lives were shattered when he was killed in McKinney by a reckless 18-wheeler driver with 21 prior driving violations. That driver should have never been on their
21 prior violations. Jesus Christ. What the fuck? See, this is what they want to keep out. This is why they don't want it in the first phase. Because anybody that hears that a truck driver had 21 priors, what if that was 21 prior DWIs? If you're in a criminal trial, defendant gets up and they say, hey, you ever been convicted of a crime? You ever gotten a DWI before? No. Well, it turns out you've gotten it 21 times, and now you're here on trial for DWI. Want to know why? Because he was driving while drunk. Same thing with these truck drivers. They want to keep the violations out in the first phase because the drivers are so bad. Why are they so bad? Because the standards to become a driver are very, very low. And to defend the drivers, they always set them up to fail. The trucking companies, they underpay them, they overwork them, and they provide them no benefits, no training, no benefits for their mental health, their physical health, nothing at all. They set them up to fail, and they tell them, drive, drive, drive. And I represented a trucking driver, a truck driver one time in a bad trucking case. My truck driver decapitated 4 people. Oh, whoa, we got some military. Hold on, I'll come back to that story. I want to hear what this is.
firefighter, just like his dad, and in so many ways, being at the same station, McKinney Central Fire Station. Next, I have Captain.
Oh, he was a firefighter, and these are gentlemen from his fire station. There's Lee Parsley looking at his phone, probably looking at photos of himself. Listen to these men. Listen to this family, Lee, because this is your bill. You corrupt piece of shit.
Jack
Can't even look at him. Look at this. He is pathetic. What a piece of trash. Can't even look at him. You know, I love the Republicans. They're always like, hey, back the blues, support our firefighters, support our EMTs. Well, this man, Lee, director of TOR, is spitting in their faces.
Also at McKinney Central Station on the shift, Jamie would come in to relieve. He was with Jordan at Texas Task Force training the morning I had to call and let him know Daddy had been in an accident and wasn't expected to make it. Next, I have Taylor Crace and Chase Inman. They are firefighters at McKinney Central Station as well. They were 2 of the first responders on scene and had to use the jaws of life to pull Jamie. Their co-worker.
Oh, Alex Goff joined the stream. Alex, my little brother, my bro. Hey, Alex. Thanks for joining. Alex is trying to get me to join the TikTok because he wants me to support the Chinese Communist Party. I am anti-China, pro-American, but he wants me to join TikTok. See, please. He's begging, please. No, we ain't joining TikTok. We're I am old. You see the gray hair. We are on YouTube. We are dedicated to YouTube. I actually think there's a way for me to live stream on TikTok and YouTube at the same time, so it really wouldn't be that hard. I don't know how to do it. Maybe I can look that up. Maybe for the next live stream, Alex is right. We go live on TikTok and YouTube at the same time. Test it out. See if we get any more views on TikTok. Comment in the chat if you have TikTok. Throw your handle on there. Everybody follow everybody. Let's listen back in.
I'm very humbled by everyone's stories here today because I know mine could have been so much worse. But from my accident.
Also, Alex actually used to run his own podcast. I think it was called the Millennial Entrepreneurs, a really cool podcast. My favorite episode was probably featuring my favorite football player, Lucas Patrick, is a player for the New Orleans Saints. Actually, not anymore. He got traded to the Bengals. Got traded to the Bengals. But anyway, Alex, glad to have you here. Benji, our other brother, Benji is Alex's and I's older brother, got 1,000 followers. Well, that's because Benji is extremely good looking. My ugly face, I can't even get views on YouTube. I don't even think my own wife follows me on YouTube. Yes, Lucas Patrick is at the Bengals.
Oldest son, and he's not here today. He isn't here today because My son was killed by an 18-wheeler driver. The driver was high. He was exhausted by driving for hours beyond his limit. The company never drug tested.
You hear that? You got the lady to her right, 21 violations. Now you got this truck driver who killed her family member because he was high on drugs. And we see and hear her tears. And what does the legislator do? 2 minutes are up. 2 minutes are up. More bribes are coming. We'll take the bribes from TLR. We don't care what you say.
The driver, he never made sure that he was safe to be on the road. And they ignored a drug ring that was set up between the drivers. The name of the company was UPS. The driver and the company has changed me and my family's life forever. My son was only 25. I would never hear his voice. I would never see his face. His life was taken in a matter of minutes. He was rear-ended.
Sometimes, man, covering these hearings, it's tough. It's tough to hear stuff like these are real people. These are real people who took time out of their day to go to the legislature to share the most horrific days and moments of their life. And our government, who is no longer for the people, they're for the corporations, they're for the oligarchs, don't care and don't listen. Let's just take a listen as to what Nichols has to say.
And I know it's thank you. We feel for all of you, and I know
we feel for all of you, but don't forget, I have taken, let's look, I'll put it on the live stream. I have taken $15,000 in bribes. You can see it plain as day. Senator Nichols, $15,000 in bribes from the drafter of this bill.
I know it's really tough for y'all to come all the way up here, listen to all these stories, participate. I can assure you there's a lot of people watching and listening to what you're saying. And
we're listening, we're watching. What are you going to do about it? What are you going to do about it? Drop the damn bill, coward.
That makes a difference, and I appreciate it very much.
Does it make a difference? Because you haven't introduced a single amendment. You haven't said on the record what you're going to do to change the bill. So just drop the bill. If you were seriously interested in your constituents, all of us that vote for you, you even take questions, dude. Why do we not get to go to Congress and ask questions? Comment below. Comment in the chat if you think that we should be able to go to our legislature and not just give testimony, but ask questions. You work for me. You tell me, Senator Nichols, why we need this bill, because so far I haven't heard shit.
So thank y'all. I'm going to call up the next panel.
See, goodbye. Goodbye. We don't take questions from you all, from the real people.
Jessica
Bye-bye.
Jenkins from Baytown, Joe Medina, Baytown, Dan Lineball from Houston, and Krista Spring from Austin. I'll be right back.
Oh, sorry, I gotta go take a dump.
You can do that, Mike. I'll be back in 3 minutes.
Yeah, Alex, it is super sad. We're only 2.5 hours. 50 witnesses are supposed to testify today. What'll happen soon is they'll get sick of hearing the witnesses and say they have to go vote on the Senate floor about some stupid bill like honoring the Texas flag, or today will be the national holiday of pancakes. And they will delay the remaining 30 or so witnesses to testify until after 7 p.m. until 1 to 2 in the morning, like we saw in SB 30 last Monday. But very sad, I agree, Alice.
I don't know, is he coming back? They're all leaving us.
Let's just start here at the far right, ma'am. State your name and your position for the bill. You have 2 minutes.
My name is Jessica Jenkins, and I oppose Senate Bill 39 on Father's Day weekend
Another
2022,
opposition.
as my husband, Michael Jenkins, was coming home for lunch.
Another opposition. We've gone 3 panels now with nobody testifying for the bill. Can you take the hint?
A commercial vehicle ran
Can you take a hint, Senate? Come on.
a red light and struck his car. We were there on the scene in time to see first responders trying to resuscitate him. I was with my 18-month-old son, who still 3 years later remembers what he saw. The driver admitted to being high. The driver admitted to running the red light.
Another driver was high. Another driver high on drugs.
Because of the current bill set.
We're sensing a theme here, folks. Sensing maybe there's a problem not with the insurance premiums, but with drunken high truck drivers. Why do they have to get high? Why? A lot of these, I've actually had these cases, a lot of them are high on meth or cocaine. Why is that? Because the trucking companies are making them drive longer hours for less money. Comment responding to Alex, a lot of them are high on drugs because the trucking companies only pay them by the miles that they drive. Therefore, the more miles I drive, the more money I can make. It's an incentive system. So I have to stay awake. I got to keep pushing the miles, keep pushing miles. How do I stay awake? Cocaine and meth. Now, what sucks for the truck driver is who's putting them in that position? The trucking company, because they're not paying them a living wage. Keep in mind, truck driving, commercial truck driving is the #1 employer for males 18 to 30. They are the backbone of our country, and they are treated like shit. Horribly. Horribly. We should be helping the truck drivers. We should be providing them healthy food, exercise, better health care, better vehicles too, safer vehicles. Some of these guys have to drive trucks that are 20, 30 years old. That's why I always say in trucking cases, they set them up to fail. I defended these folks for years. They set them up to fail. And who suffers? You and I. The folks on the highways, focus on the streets. As we heard from a witness earlier, a school bus full of children who was hit by an 18-wheeler.
Friday afternoon, and the truck driver was on his phone at the time of the impact with his employer because he was being told to come back to the shop because it was payday. After the crash, DPS officers told the driver and the owner of the company to take the truck back to the yard and lock it up to secure it. He took it back to the yard, but he took the dash cam out of the truck. And when that dash cam got back to the judge, it had been forensically wiped clean. No evidence now exists, which could have been very important in our case going forward. My son, Graylin Spring, was traveling to Houston to support members of the SFA track team and never made it. He deserves justice.
Thank you.
He deserves justice. I agree.
Thank you, ma'am.
But Senator Nichols does not agree with you.
I'm an attorney from Baytown, Texas, and I oppose Senate Bill 39. A minute ago, you heard from Jesse Jenkins. Jesse's husband, Michael, was fatally injured in a commercial vehicle crash. Some of you may have known Michael. Michael had worked as an assistant to Mays Middleton when Mays was serving in the House. And it wasn't too long after that service that he was fatally injured in a crash, leaving behind Jesse and her son, PJ. You know, as an attorney, I see a cross-section of trucking cases. And what I found is that the trucking companies that are the safe ones, that have good safety protocols and safety programs, they're not afraid of the truth. They'll put the truth out there. In fact, I'm going to read to y'all a section that comes from J.J. Keller, which is an industry leader in trucking. And here's a passage that talks about finding the answers to why the crash occurred. And here's a statement from one of their safety people. The theory of multiple causation says that there's more than one thing involved in causing an accident. Most people tend to look at one cause. This does not go far enough back to the root cause. And it goes on, it says, be prepared, for many of these root causes wind back toward company management. Here's the point that even the safety folks know. It's not just about the driver at the intersection at that moment in time. It's about who trained him, what mistakes were made. It goes on and it says, we find that 90% of all accidents are caused by management. The employee may have made the
90% of all accidents are caused by management. Lack of training, lack of supervision. None of that will come in under phase 1 of the bill. Why do you think they want that excluded? You've heard the testimony from real people.
Driving here, but why did he make the error? It's about the root cause. And what's happening here is small trucking companies are trying to mask the truth. We've all heard it said, the whole truth and nothing but the truth. The jury needs to have the whole truth so they can have context and say what really caused this and assign appropriate percentages. Thank you.
Thank you, sir. Please state your, hold that mic over. Thank you. Please state your name for the record, sir.
My name is Joe Medina from Baytown, Texas, and I oppose the Senate bill. 7 years ago, my daughter was T-boned in a truck accident. But I don't want to talk about that. I want to talk about the truck driver or the truck company. He was a Cuban. He spoke no English. They ran this company out of an apartment complex. They had no kind of safety program. What they said in court was they looked at YouTube videos, and they had no records of anything that they had said. They said they did parking lot meetings before and after, and none of that was recorded. He never stopped at the light. There was a video showing where he ran it. All they kept saying was it was a simple mistake.
Simple mistake.
His license, it took him like 3 times to pass it. It was in Florida. He was working for like a cousin or another guy from Cuba that just hired him on the spot. He didn't care what kind of safety or what kind of training he had.
Right. Why would they?
And I think if this passes, more stuff like
Safety's
this
not a
would just be
priority, and the
happening.
legislature will say you don't need to be safe.
Thank all of you for coming. Very sorry. Thank you for coming here. We'll call up the next panel. Mike Lufkin, Brent Taylor from Dallas, Michael, looks like Levens from Austin, Michael, Ware Wendell from Austin. So go ahead and start on this side, sir.
Good afternoon, folks. My name is Mike Love, Senator Nichols. I'm in your district. I work in Lufkin, Texas. I am an attorney, have been for 27 years. I practice 18-wheeler litigation. That's what I do. I've given dozens of CLE speeches to the state bar on both sides, defense, plaintiffs, both sides. And I want to tie something together for you. Hopefully, I want you to have an epiphany moment here. The stories that you've heard today have one thing in common. I'm going to share with you what I said in one of the very first CLE speeches that I ever gave to both sides, defense and plaintiff. And that is, these professional truck drivers, they're skilled. They know what they're doing. They're highly technically skilled people, because you and I drive 10,000 miles a day. They drive a year. They drive 150,000 miles a year. They're good at what they do. So take any normal little crash together, 2 cars, a truck and a car come together. Odds are it's the car's fault, not the professional driver. Because you and I can make a mistake just because we made a mistake. Michael Jordan doesn't miss a layup without there being a reason. And these professional truck drivers, the thing that comes in is if it turns out that it's the driver's fault, folks, there's almost always an underlying reason. And that's what you've heard today. Okay? There's almost always a systemic failure of the company to enforce safety rules, because these guys are good. They don't mess up for no reason. It's driving over hours. It's pushing the load, or not being trained, or it's some underlying problem that causes it. And this bill already is a problem, because general negligence is like when you're doing everything wrong. It's just a matter of when, not if. And we're already limited in lots of ways. And this bill takes out the evidence for the rest of it.
Ware Wendell, my boy, Ware. Texas Watch, about to testify. Love listening to this guy.
Thank you. Please state your name, sir.
That's Mike Love. I'm Michael Levens. I don't know how anybody planned that, but well done. I'm here in opposition to SB 39. I'm an active Republican. I'm a trial lawyer. I represent the Travis County Republican Party and several other conservative causes in litigation. I'm here to give a cold, emotionless defense of the free market. And this bill is precisely designed to damage the free market by creating a market failure. The elephant in the room today is that the purpose of this bill is to save big insurance companies money, and to do so by hiding important information from the jury. The tragic stories that we've been hearing today are instances of trucking companies creating extreme costs. Economists call them negative externalities, which doesn't sound very interesting. But it takes those costs and imposes them on others who didn't create them, the ones who are killed and maimed by these companies. A proper free market dictates that those who create the costs bear the costs.
Those who create the costs bear the costs. I like that a lot.
This bill is precisely designed to create a market failure. And we talk about the phase 1 and phase 2 and all that stuff, but this is really about saving insurance companies money by allowing them to impose massive costs, death, maiming, and utter mayhem on people's lives, and they don't bear. This is really about saving insurance companies money by allowing them to impose massive costs, death, maiming, and utter mayhem on people's lives, and they don't bear the full cost of that. This bill may be considered pro-business, it may be considered pro-insurance, but it's anti-individual. And as our representatives, your job is not to take the side of business or insurance or individuals. Proper conservatives take the side of the free market and personal accountability.
Property conservative. I love that testimony. Yeah. We're free market conservatives. Why are we not letting the market decide? The markets decide that if you cause harm, you pay for it. But here, we're socializing the losses of the trucking companies.
Which is a fundamental tenet of conservatism, says that those who create the costs must bear the costs. This bill would do precisely the opposite of that, and that's why I urge you to defend the free market and oppose this bill. Thank you.
Sir. Please, go ahead.
Ware Wendell with Texas Watch against Senate Bill 39. For over 25 years, our nonpartisan nonprofit has advocated for safety and accountability in our state. You, as lawmakers, are being asked to contort the law for the second time in just a few years. And you're doing it in a state where large trucks kill and maim more citizens than anywhere else in the country. Anywhere else. This is federal data. Since at least...
That's a fact. That's not an opinion. That's a fact. We kill more people in trucks here in Texas than anywhere in America. Why is that? Well, we have Houston. We have a huge Gulf of America, not Gulf of Mexico. See what I said there? Although I think that is really stupid. But, well, if we're told to call it Gulf of America, I'll call it Gulf of America. We have a huge Gulf of America and connections to California, New Mexico, Nevada. We're a hub for trucks. So it's really not, it's not the trucking company's fault that so many trucks are on the road here. It's because of our ports. But it is the trucking company's fault, for reasons I explained earlier, why we're leading in deaths.
2017.
And also our legislature, we refuse to hold them accountable.
Texas is ranked first in the country for the most large truck crashes. Since the bill was passed in 2021, the trucking industry has taken over 3,200 lives in Texas. They've injured over 45,000 Texans. When you put this in context, that's about double California, about triple Florida, other large states. There is a safety crisis on our roads. The problem with the legislation is there are no safety reforms in it at all. The complaints are about insurance premiums. There are no insurance reforms in the bill at all. We know that Texans across many lines, and y'all see me testify on this often, are suffering higher insurance rates. We need prior approval. But the industry, the property casualty industry, has been over-reserving. They've been hoarding cash. They've doubled their reserves since 2004 and jacking up our rates. So we need safety reforms. We need insurance reforms. We don't need more tort reforms. We've had 4 decades of it, and it's only helping the insurance companies, and it's only punishing the innocent. The jury deserves the whole truth, nothing but the truth. They deserve it up front. I ask you not to hide the ball. And Mr. Chairman, I will close on this. I have just a few seconds. I appreciate you being here throughout the entire hearing. Many of your colleagues were not able to hear from the families. It's been our privilege to work with many of the families today. I would ask you as a matter of honor to please share with them what you have heard, because it is the most heartbreaking testimony.
It's heartbreaking. Thank you.
Good afternoon. My name's Brent Taylor.
Turn the mic toward you.
Sorry. My name's Brent Taylor. I'm
There you go.
Secretary Treasurer and Business Manager of Teamsters Local Union 745 in Dallas. I'm also a Southern Region Vice President of our International out of Washington. I oppose SB 39.
Wow.
Me personally, I've driven trucks that we're talking about today. I've driven less than 10,000
Wow. Trucking union even opposes the bill.
pound, less than 20,000 pound, and I've driven the 80,000 pound trucks. And there is a lot that goes on.
I think Tesla's, Alex, sorry to wait and answering your question. I think Tesla's dash cam is only recording for parked vehicles. Let me think back. I did have a Tesla case where the client said that he had the crash on video, but where the crash occurred on his car actually destroyed the camera, I think, inside the Tesla. Let me look that up real quick. I'll get back to you.
When driving a truck.
Good question, though.
But what I'm hearing today, and I've sat in here since minute one, listening to all this testimony, we're talking about who's liable. We're talking about the driver, the company, the insurance company, and in my opinion, like one of my constituents down next to me said earlier, in my opinion, it's just a scam between big corp and insurance companies. That's all this is. Because I don't know how much you think a truck driver makes, but if a jury decides the company is not at fault or the insurance company has nothing to do with it, and a truck driver's making $60,000 a year, what do you think the victim's going to get out of that? Absolutely nothing. We're talking about deaths, people being maimed. So to hold a truck driver accountable for something like that, something that tragic, I think is not the right thing to do. Understand, a truck driver is the arm of the company when they're driving that piece of equipment. It's the company's piece of equipment. They're just an arm of the company. To give you, for instance, if you walk into a Costco and a forklift driver backs into you and breaks your ankle, who are you suing? Are you suing the forklift driver? He's on a piece of company equipment. He's drawing money for his services from that company. Would you sue the forklift driver? No, you're suing Costco and their insurance company. Thank you for your time.
Thank you, sir. Thank all of y'all for coming. I know you spent all day, or all morning anyway. I appreciate it. Call it the next panel. Brian Dennis, Fair Oaks. Adam Blanchard, San Antonio. And Anthony Home from Driftwood. My daughter lives in Driftwood. And members, I'm showing this is the last three. We'll call. I have all of these cards wishing to not testify, but shown the position. Is it okay? We all instead of reading them, we'll just put them into the record. Okay. And so please state your name for the record, sir.
Brian Dennis. I'm here opposing SB 39. I am a trial lawyer. I represent those that are injured. And we just had the misfortune of having a trial in February.
This guy on the left owns his own trucking company, so I'll be interested to hear I think it's a pretty small trucking company, so it'd be interesting to hear his perspective. He gave really good perspective on how the premiums have gone crazy for his business. I think went up into the 6 figures. So it'll be interesting to see how his testimony differs from what we heard from him, if it's the same witness in SB 30.
For a lady who lost her husband.
Just a reminder for everybody tuning in, we are here covering SB 39, the latest trucking tort reform bill. Thank you for joining us. Thanks for listening in. I really appreciate it. It's always good to see you, to meet with you, to chat with you. Even my little brother's here, Alex Goff. I really appreciate his support. And if you disagree with Alex Goff and think we should remain on the American-made TikTok, comment in the chat for me, please. Thank you.
35 years. The driver who caused the event was a Mexican national with a Mexican driver's license with no proof of training. When he was hired, the packet included his name and his date of birth. The date of birth was wrong. There was no testing, there was no training, there was no vetting. He was hired because he was the lowest, cheapest person available to do the job. He was hauling 3 layers down for a company that made plenty of money, that wanted to offload its responsibility and put the motoring public of San Antonio at risk.
My wife has officially joined the chat, joined the views. We're up to 2 concurrent viewers. Let's go! We're going viral, baby. Covering the legislature. I hope people know. Let me actually take a moment here. Let me check in on the... Whoa. My light just went out. That was weird. Oh, I need to restart OBS. Oh. Damn. Okay, I'll do that on the next break. Need to restart OBS. Thank you, Monica, for joining us here. Keeping it in the family. Got Monica Goff, got Alex Goff. Hopefully, maybe one day we'll get Brittany Goff on here. I would love that. Good question. Yeah, we were trying to address that earlier. Do Teslas have dash cam? Yes, they have a built-in dash cam called Tesla Cam. Okay, I want to hear this guy.
CEO of Double Diamond Transport and Tanager Logistics, both headquartered out of
This is a trucking company out of San Antonio. We heard from him on SB 30.
Antonio, Texas, and I am here today to testify for Senate Bill 30.
Oh, okay. We got someone for the bill.
39. First, I'd like to thank, although I know Senator Birdwell is not here, thank him for his authorship of this bill. I was heavily involved with House Bill 19 2 sessions ago, and
yeah, which passed. So what's your issue?
am now back discussing some of the consequences of that bill that I think we can clean up with Senate Bill 39. I think it's important to begin with of what this bill does and what it does not do.
This guy's not a lawyer. Let's keep in mind he's a truck driver.
Our hearts go out to the families, and many of which you have heard from today, that have been injured in truck accident cases. We as an industry want to compensate those people that have been injured in these accidents to the full extent allowed by the law, and we don't want any bad actors in our industry. But I think
he's right. I think he's telling the truth on that. He said the same thing for Senate Bill 30. I think he's saying that.
It's important for this committee to understand that this bill in no way inhibits people's access to the judicial system. It does not in any way.
No, it allows you to file a case. Wow, what a low barrier to entry. Thank you. It only screws you when you go to trial.
Inhibit their ability to be fully and completely compensated for the accidents they're here to testify about. This bill simply allows us to focus in the first phase of the trial on what was the accident, who was at fault, and how do we make this person whole. Senate Bill 39 simplifies the process that was provided in House Bill 19 and in my opinion, removes some of the unintended consequences that have been a result. I think both sides could agree that the fact that those regulations that are mentioned in House Bill 19 that are currently in statute, they can only be introduced into evidence as it relates to the negligent entrustment claim. Those certainly should be introduced if it relates to the negligence of the driver. And so I think this bill very much cleans up some of those unintended consequences and, in fact, allows more evidence to be introduced in the first phase of trial.
What allows more evidence by eliminating all of the exceptions that were argued 2 years ago? And what are you talking about?
Of those that have been injured. I think it's also important to note that 72.054F, I know it was mentioned before, related to negligent.
I need you to close.
Sorry. They still can go after the companies for those reasons.
right,
For these reasons, I ask for your support of Senate Bill 39. Thank you.
Thank you. Please state your name.
Yes, sir. My name is Anthony Holm. I'm opposing to the bill. I'm here on my individual self. I happen to be a trial lawyer, but I'm also a truck driving school graduated qualified.
Oh, this guy, this is Big Dog, I think is his website. This guy testified, did a really, really great job on SB 30. Well, hear what he has to say.
Hazmats and tankers. I'm one of the people, probably only in this room, who's successfully driven a semi up and down 35, where they're referencing those deaths in the last 5 years. This bill, though small, strikes this many federal regulations from admission in phase 1 of the trial. So here's what we have. We have CFRs. The federal government said, hey, trucking is so dangerous. So many people are driving 70,000-pound weapons 70 miles an hour. We're going to have minimum standards. And here are some of them. These are currently admissible in phase 1. They will not be admissible if this bill passes. And there's 30 or 40, but there's 12 or so that I want to make sure that you guys are aware of. Some of them have come up. Admissibility of can't read or speak English. The admissibility of do they have a valid CDL? If those aren't proximate harms of the injury, then they won't be admissible if this bill passes. Amphetamine use 3 days prior to the crash. That's not going to be approximate harm today, but if somebody's been up for 36 hours, I think this body might be inclined to let the jury be aware of that. You're being asked to vote to oppose that. I've got 12 or 15 that I think are substantial. 0.04 blood alcohol. This just cut off.
We didn't do that. We didn't cut off. Keep going.
Okay. It is, for example, illegal for a truck driver to drink a few beers before they go on job. Probably makes sense, even if they're not intoxicated. That won't be introduced unless it's causative, unless it's proximate cause of the harm. And it's amazing, I think, that this body's being asked to vote. If somebody shows up half drunk 4 hours before they go on their rotation, that's not admissible because that's currently the law. And there's a whole bunch of others. Texting and driving, phoning and driving. Yes, sir.
Thank you very much.
Yes, sir. Thank you. And I'm open for questions.
No questions. You do have a question? Senator Hagenbull?
Mr. Blanchard?
Yes, Senator.
Appreciate your testimony. I appreciate you being a trucking company owner, but expressing your heartfelt concern for the folks in these accidents and your desire to express that. And we do, your point that you don't want those going on, and you want full prosecution of those people and those trucking companies that are bad actors. And you believe this bill will let them off the hook or any way, or make it harder to go after those kinds of trucking companies?
What a softball. No, this isn't going to hurt anybody who's seriously injured, right? Trucking company owner? Oh, what a softball load of shit.
Senator, not at all. In fact, quite the opposite. I think that this bill, and to, I guess, rebut the testimony of the gentleman next to me, is those regulations that he just mentioned, evidence of those, every single one of them can come in. It can come in. If the driver was intoxicated when the accident occurred, certainly that's going to come in. If he was texting and driving, that's going to come in. All of the things that they shouldn't be doing, according to our federal regulators, are going to be a component of the cause of the accident that will be introduced. And so this bill in no way inhibits people's ability to file suits against trucking companies.
That's a lie. Well, yeah, it doesn't inhibit your ability to file suits. It's not what we're talking about. We're not talking about a heightened pleading standard. We're talking about trial and bifurcation. Nobody is mentioning anything about
it doesn't in any way inhibit their ability to introduce evidence at these trials related to what was the cause of the accident, who was at fault. In fact, in the second
Yes, it does.
phase of the trial, just like a criminal case, they can bring in everything to punish those bad companies. And in fact,
you can't bring in everything. You can't bring in everything.
I find it very interesting that many of the people that have come here to testify before you in opposition of this bill are not discussing the fact that the law as it currently sits today.
Okay.
It was part of House Bill 19. Limits their.
I think you answered his question.
Their evidence on
Did you have
coming
another
in.
question?
Yes, sir. Someone talked about, one of the previous people talked about the free market impact of this. How do you think the free market is working in terms of how the balance is working out between trucking companies and their economic success or ability to survive and law firms, trial law firms?
Oh my God. How does the free market, well, so do you want the free market or do you not want the free market? I mean, which do you want? Okay, if the free market is hurting the trucking industries, then maybe you need more competition. You can't think this is so too speaking out both sides of his math.
If you want to talk about true free market economics, we are losing resoundingly. In fact, none of
then you suffer as the market does.
the insurance carriers, we're seeing many leave the state of Texas as a result of the litigation.
No stats, no proof of that. He's just making that shit up.
In the state of Texas, it is causing trucking companies to go out of business at a disproportionate rate to free markets. And in fact, it is making the roads less safe. I have 4 children that are on the roads with my wife, and we now have to have less insurance. It was mentioned earlier about punitive damages being excluded from many policies now. That's because of the litigation environment that we're here to address. In addition to that, many companies like mine, I run 90 trucks. I'm having to now take the first $75,000 of every claim myself in order to get the insurance at a rate that I can afford. And so the suggestion that this is just here to help big insurance companies is just fundamentally flawed. Many of us now are having to retain the first $75,000 or $100,000 of every lawsuit and every claim that we have, and so it's hitting us in our pockets and the people in which we employ in our communities.
All right, thank you. Thank you. I appreciate this. Appreciate all y'all coming. Is there anyone else here who would like to testify on, for, or against Senate Bill 39 of the committee substitute?
There's no way that was 50 witnesses.
If not, we'll close public testimony. We'll leave the bill pending. I'm going to, chair lays out Senate Bill 2246. Ask Senator West to very quickly lay out the bill.
Very quickly. Members, this deals with salvage auto dealers routinely purchase.
All right. That is it for the, let me get centered back up here. That is it for testimony on the new trucking bill. Okay, so that was really interesting. Heard some really good testimony. You see the quotes below from some of the people who showed up. Now we'll go to the Texas House of Representatives. There's a parallel trucking bill. Let's see what's going on with them. We can see if they are live broadcasting. I was just texting with Will Moyer, one of the people who was inside of the Senate, one of the guys who testified in the Senate, sorry. And he said they were not
47 ayes and 0 nays.
House Bill 12 is currently before. Okay, so they're live on the House floor right now. House Bill 12. Let's see what that is. Looks like Burroughs. Audit of State Agency Operations. Okay. Now it's House Bill 1522. That is. So the House floor is active, meaning the committee members in the House are not meeting. They're paused, at least until the House floor is done voting. So let's do this. Let me stop this live stream. Nothing really to cover. Let me get some water. Everybody take a break. We will come back after our break. I'm actually going to go eat lunch, I think. Go eat lunch. Then we'll come back, hopefully get to cover some of the House testimony and hear more about bills that are screwing you over because our legislators are bought and paid for. Legislators are bought and paid for taking bribes so that you can be killed by a truck driver. Pretty simple. All right. We are over and out. I'll see everybody this afternoon. Thank you. Thanks for tuning in, everybody.